Yeah, I'm going to do the intros. I'm Terry Bonzer. I'm the chair, and I'll start off with Romeo. You can introduce yourself.
Romeo Dene.
Teresa Bascom, Vice Chair.
Bonnie Winona McKinnon.
Okay, I'm going to read the rules. I will, before each hearing, I will call the hearing in session and read the application. Each person who appears shall state their name, address, and indicate the affiliation to the case. I missed one. Board members may ask questions at any point during the testimony. Any member of the board, through the chairman, may request any party to the case to speak a second time. Any party to the case who wants to ask questions of another party to the case must do it through the chairperson. The applicant shall be called to present their case, and those abutters in favor shall be allowed to speak. The abutters and in opposition shall be allowed to speak. The board will hear any evidence that pertains to the case from the other parties that wish to speak. The applicant and those in favor shall be allowed to speak in rebuttal. Those in opposition shall be allowed to speak in rebuttal. The chairman shall present a basic summary of the case. The hearing will be closed, and then the board will discuss the case and vote on it. We can vote on it tonight, or we have up to 30 days to make a decision, so. No, here comes Kevin. Okay. They're ready.
How you doing?
I was just ready to say we only have four board members, but now we have 5. So, okay. So I'm going to read the case. So our first case, case A, is 21-008-VA. This is an application from Tammy DeFresco and James George for a variance from Article 2, Section C of the zoning ordinance to permit watercross events with incidental camping, i.e. commercial use, 3 weekends per year. The property is located at 214 Raymond Road in Nottingham, New Hampshire, and is identified as tax map 69, lots 8 and 10. Okay, I'll open up the hearing to you. Now, we want to try to refrain to just, we've heard this case twice, 2 or 3 times. We're in for a rehearing tonight on this case. We've heard 5.5 to 6 hours worth of testimony already. So I'm going to try to limit it to just new stuff that's presented.
Except that
You only want 4 hours of new testimony.
Yeah,
Funny.
right. We want to try to limit this because we got 2 more cases. We've heard this case and
I
really just
understand-
new stuff, so.
I understand the
Excuse me,
need for the board.
point of order.
Yeah.
You do need to seat Kevin because he's the alternate.
Oh, yes, I should, yep. Okay, I'm going to seat you, Kevin, as an alternate for Raylene. So
Thank you.
that's a 5 board. Thank you for mentioning it. Okay, go right ahead.
Okay. My name is Brian Bouchard. I'm from the law firm of Sheehan, Bass and Green in Portsmouth, and I represent the applicants in this case, Tammy DeFrancesco, James George, and the Prohibited Trust. And Mr. Chairman, with your permission, I normally speak or stand when I'm addressing the board, but
Oh, fine.
I'll sit for
No,
tonight's
you
purposes.
can,
Okay.
however you feel comfortable.
And together, the applicants are the owners of lots 8 and 10, which is the subject property on which a variance is sought to permit watercross events for 3 weekends a year: spring, summer, fall, Monday to Sunday. A few preliminary notes. First, what you have in front of you is a letter that my office sent to this board in August. I revised it today. I think I accidentally sent you a draft version mistakenly. So I just corrected some typos that unfortunately I had submitted to you, so my apologies there. Otherwise, the letter is substantively the same as what I had sent you in August. I know that the board has hearing this now for the third time, as Mr. Chairman pointed out, and that there may not be need for any further background, or, background may at this point be repetitive or unnecessary. At the same time, we are here at a rehearing, and so the board is in some ways hearing it afresh. So I do want to make sure that my bases are covered and revisit some of that background. I will be brief, sir, as brief as I possibly can be.
Okay.
But I just want to make sure that we do round the bases on our way to home, okay?
Okay, yep, not a problem.
So my presentation is going to be two parts. One is background that we'll talk about first, and then second I will go into the elements of what you need for a variance, and I will try to focus my remarks on new information before the board. And I understand that there's a little bit of a dispute as to what constitutes new information. My client had submitted a property survey from property evaluation report from Mr. Lavoie prior to the June 15th hearing, and I think there was some dispute as to whether or not that was properly before the board. For tonight's purposes, I will treat it as if it wasn't and address it as new information. Okay, and of course I welcome any comments, questions from the board as we go forward here. So this is a project for 3 watercross events, as I said, a year. It's going to be in the spring, summer, and fall. It is my client's goal not to have these events during lake season except for one event during the summertime. The spring event will be sometime in late May, and the fall event will be sometime in late September, early October. They will occur on Friday, Saturday, Sunday. Friday would be 4 to 6. Friday would be 4 to 6. Saturday would be 10 to 6, and Sunday would be 10 to 6. The way the events typically work is there's a morning session of drag races that goes from 10 to approximately 11:30. There's an hour break. Then there's another half hour for patriotic gestures such as the national anthem. And then races resume around 1:30 and proceed until 6 o'clock. I did deliver to you a site plan. I'm sure you've seen this site plan at least 3 times before. I'm not going to revisit it. The only thing I will note is that at the suggestion of the planning board, the campers are going to move south to be almost exclusively on lot 10. And the parking for the event will then move north to be on lot 8. That's the only substantive point that I need to raise with the board tonight. In reviewing the minutes, and I've watched both the June 15th hearing, I think that there was a hearing in May, and the July 17th hearing, I think something does get lost in translation here, not necessarily from the board's comments, but from many comments from the abutters. And that is this. The application for a variance isn't to use snowmobiles on the water. My clients can do that already. It's private property, there's a pond, they can race snowmobiles up and down sunrise to sunset. What the variance is for is to host commercial events in a property that is unfortunately zoned residential. And the reason I use the word unfortunately here is I think, as you'll see in my letter and as you'll see in my presentation, this property is almost anything but residential. It's an active gravel pit of over 40 years next to a major thoroughfare in the town of Nottingham. So I just want to clarify that point, that this isn't a variance to race snowmobiles on the water. That's not the purpose of it. The purpose of it is to host the events, albeit those events are racing snowmobiles on the water. And finally, in my remarks here, or not finally, but second to last, I want to make clear to the board that my clients are process-abiding individuals, and they are here in good faith this evening because they believe in that process and they believe in the agency of this board. My clients, over the course of almost 2.5 years now, have made sure that they dot every I and cross every T with respect to hosting these events on their property. That's included obtaining necessary open air permits and event permits from the Board of Selectmen. Once the Selectmen understood that they wanted to host 3 events for a year on a going-forward basis. The selectmen sent them to the planning board. My clients happily went and are still going through iterative designs with the planning board to this day. And then the planning board then sent them here to the ZBA because the property is zoned residentially, notwithstanding the fact that it has a substantial industrial operation on it that's existed since the 1970s. And in addition to the processes and the applications that my clients have submitted to not only this body, but the town of Nottingham at large, they've obtained necessary permits from the New Hampshire Department of Environmental Services, alerting NHDES that there will be watercross events on the pond and on the property. They've obtained permits from the New Hampshire Fish and Game Department. They've obtained permits from New Hampshire DOT. And they've also checked with Epping and Raymond, perhaps in a bit more informal fashion, to ensure that watercross would not be obstructionist to either of those towns. My clients have worked ardently to make sure that the board has the information that it needs to make a decision on this matter. And I think the board can rest assured that the conditions we're proposing here, that my clients will certainly abide by them, given the lengths they've gone through to make sure that they abide by the processes. Finally, we are here in a rehearing. As you'll see in my letter, I don't believe that the board's decision to grant a rehearing was proper, though I understand why the board did grant the rehearing. First of all, the abutters, the so-called abutters who submitted the request for rehearing, I don't believe that they are actually abutters with proper standing to request rehearing, and standing is necessary. 3 of the individuals are at Indian Run, which is almost a mile from the property. There is no direct connection to them in my client's property. And then one of the abutters who filed a request for rehearing is a tenant in the condos near my client's property. And it is clear from the statute that standing is only conferred upon someone who owns land, whether that's good, bad, or indifferent. That's the way the statute's written. And it is our position that a tenant is not someone with standing to request a rehearing from the board. Further, I don't think there was anything procedurally infirm, contrary to the abutter's letter, of what the zoning board did. The governor lifted his emergency order on July 11th. You had already noticed the hearing. What was the board to do? There's nothing in the statute that I read that requires public hearings to absolutely occur in person. Portsmouth right now is still doing a hybrid of its hearings, notwithstanding the governor's order. So I think that the June 17th decision was valid, though I understand that the board may want to have to correct any type of procedural infirmity that was alleged and rehear this matter tonight, and of course we are able to do that. I don't think, and my clients believe, that the board should change its decision from June 15th. Nothing has changed in this matter that would warrant the board not to grant a variance. In fact, I think the additional evidence that has been submitted supports the fact that a variance should be granted. And I'll just give one example here. Board member McKinnon, during the June 15th hearing, I'm going to paraphrase what you said, you had asked my applicants whether or not the watercross events would present some type of hazard to the drinking water of those in the area or those who rely on the aquifer. And you were dissatisfied in the answer that was provided. We have now answered that question. And I have George Holt with me tonight, who's already submitted a report. And it's his belief that, to a reasonable degree of scientific certainty, that the watercross events would not pose a hazard to the drinking water of any of the surrounding properties. So we have answered that question and hopefully removed an obstacle for the granting of a variance. If you also look at Mr. Lavoie's property valuation, he is an appraiser from Bedford, and he draws the conclusion that due to the current obsolescence from Route 156 and an active gravel pit that has existed for 40 years, that the properties in the surrounding area would experience no diminution in value. And to the best of my knowledge, both of those reports are uncontroverted by any other expert. And I'm going to pause here in my opening remarks in that I do have Mr. Holt here with us tonight. He is happy to answer questions from the board that you may have regarding his report. And I'm sure you're already tired of listening to me drone on for what is 10 minutes now. So I'm going to give you a brief break from that.
Jared, is his microphone transmitting to the crowd?
You need me to repeat everything I just said? I mean, I got some of it written down, but not all of
Just
it.
asking if the microphone was actually picking up.
I hope it was.
We won't know until we hear from somebody on the outside.
Okay.
Right, my wife was watching the meeting, she was gonna call if there was
The
a
green light's
problem.
on.
So,
Yes.
I'm hoping it's worked. Okay,
If the board has questions for Mr. Holt, I understand that he likely cannot stay here all evening, but I wanted to make sure that the board was given an opportunity to address any concerns or ask any questions that it may have about his report or his conclusion that the presence of water cross on the property will not have a negligible or will not have an adverse effect on the aquifer or anyone's drinking water.
does anybody have any questions? Okay.
I don't have a question about the drinking water, but I wanted to go back to your statement about diminution of property values,
Sure.
because I don't agree with that appraiser's statement.
Okay.
And I have worked in the real estate business since 1977. I worked in a family building business for 25 years in marketing privately, and since 1977, I've had a license. I've worked for 2 corporate real estate firms, and I've started 2 firms of my own. So I've owned a real estate agency. So I just want to point out that an appraiser typically gets involved in a property sale for the lending institution of the buyer. And this happens after the property marketing value is determined by the broker, who uses sales data available to her. Then the broker and the seller agree on a marketing price and submit a listing of the property to the market through multiple listing usually. The property is exposed to the internet now and is advertised all over the place. So someone finds a buyer who makes an acceptable offer, and only then is an appraiser called. So I don't think he's in the position to evaluate the market value of properties. I think that the brokers is more in that.
Sure.
Catbird seat.
I understand your position, and I would respectfully but wholesheartedly disagree with you.
Well, I'm not finished yet, if you'd let me continue.
Sure, I will absolutely let you
So
continue.
I definitely believe the value of the properties that abut this request would be diminished some. And mostly it's because it'll be a nuisance in terms of noise. And I'm not talking about noise as a scientific subject, just as a fact of this event. And I had a statement here that I wanted to read if I can find it, but it might take me a minute, so I'll just move on first.
I'm happy to bear with you. This is in many ways the board's show.
So additionally, I think the value of nearby properties would definitely be diminished some. And no one could have a successful showing of a house on the days that they're racing these machines. You couldn't have an open house in the condos next door, or even any of the abutters who are in favor of the racing thing, of the racing events. I mean, I'm not against them, I'm just not in favor of where they're at, and I'm not in favor of diminishing people's property values. So additionally, from working in real estate for a long time, I own property in the town of Lee, which abuts Nottingham. Lee has a famous or infamous racetrack, not a watercross racetrack, but another kind of racetrack. And the town of Lee just got reassessed by cross-country Appraisers Group. Cross Country Appraisers is owned by a guy named Jeff Earls, who's been in the assessing business for at least 30 years, before which he worked for the New Hampshire Department of Revenue Administration. So I had a post-assessing appointment with Mr. Earls to go over points on my own properties in Lee. And after my properties were done, I asked him about the properties near the Lee Raceway, just to see how they were dealt with from an assessing perspective. And he said that in Tamarack Acres, which is a subdivision behind that racetrack, many of those lots abut the raceway. He gives the houses a 3% economic depreciation off their value and gives 3% economic depreciation on the land. Additionally, the neighborhood is downgraded one level, all of this because of the racetrack. So this creates a loss of revenue to the town, which then has to be made up by other taxpayers. And, you know, the main reason for the value diminishing is the noise. So I found the statement I was looking for. This statement was on Facebook on June 29th, 2021, which is about 2 weeks after our June 15th hearing. And the statement is by Steve Reynolds. He is the owner of Northeast Watercross Championships, which is the company that will be administering or running these events. And he said, and I quote, "Hello all, as most of you know, I'm the owner of Northeast Watercross Championship. While many assume this is about money, for 2021, I am waiving all general admission fees for Nottingham residents. This does not include pit pass, as that is tied to insurance, and it does not include camping. Present a valid, non-expired ID at the gate, and admission is free." So he's inviting the whole town. "Check out what most of you have never seen, and see the passion of these racers and families that enjoy these events." And his next statement is the one that I think is the most important. "We aren't denying these events are loud and going to be a nuisance for some, because, well, that would just be false information and, in bold terms, a lie." So that's Mr. Reynolds' statement after the approval. And he spent a lot of time in the board trying to convince us that it wasn't noisy. So I thought this was kind of a bold statement for him to make, but perhaps a more real one.
Yeah, so if I may comment. First, with respect to Mr. Lavoie's qualifications to assess property. I've been doing this for a good bit, and when I'm asked to submit information on whether or not a variance will adversely affect property values, I only use an appraiser. And I have never had a board member challenge that in any other town, nor am I aware of any New Hampshire Supreme Court or Superior Court decision saying that appraisers are somehow insufficient or not up to that task. Further, if you look at the divorce law, for instance, when a property has to be appraised for a property settlement between the divorcing parties, it is quite common to use
I'm aware of that, but that doesn't go on the market. That's not a marketed property.
Sure, but what we're examining here is whether or not there would be a diminution of value, and we have a qualified expert saying that there wouldn't be.
And I think that I'm a qualified expert, and so is this assessor that I spoke with.
So,
so that's one opinion, and I have a different opinion, and so does the guy who assessed the town of Lee.
I understand. Unfortunately, I don't know what Mr. Earls said. I wasn't able to talk with him. I don't have a reason to.
Thank you.
I guess what I'm getting at is there's always nuance in every conversation. I haven't talked with him. I can say that the law in New Hampshire is pretty clear with respect to what ZBA members can bring into the hearing. And that is, everyone you're a judge and jury, everyone comes with their own knowledge base and predilections. But when there is uncontroverted expert opinion as to whether or not property values would be diminished, this board respectfully cannot just ignore that. You can wrestle with the evidence, but you can't just cast aside Mr. Lavoie's expert report. Further, Lee isn't the same as this property. My understanding of Lee, and I'm not an expert in Lee, is that those events run all summer and that there are,
No, they don't. They run on weekends.
They do,
They run on weekends.
Yeah,
I think there's,
which is all summer.
They're on weekends in the summer. We
I-
can hear them at our house.
I think there's people behind me that would disagree, but my understanding is they do run all summer, and that the neighborhoods that may be in question in Lee look materially different than the neighborhoods here. I think there you're dealing with like quarter acre lot developments, which I think Mr. Lavoie accounts for in his report. And finally, to the extent that property values would be diminished, I would disagree in that, Tammy is a broker. She just listed one of the condos that abuts the property for approximately 27.5% more than what it was purchased for in 2018. There were 3 watercross events in 2019, many...
2020.
2020. And some of the people who attended the open house today were emphatic and enthusiastic about watercross events occurring in that area.
Well, can you,
If asked to testify as well, I think Tammy would say that the increase in price of 27.5% is commensurate with other properties that she has seen in the area and in the town.
I don't think a person with young children would buy it, though. Because,
I
One of the
think-
condo owners is here that lives there.
I think that may be addressed by one of the condo owners in terms of the abutter comments. I understand your points. I take them. I just happen to wholeheartedly disagree with them, and think that Mr. Lavoie's uncontroverted expert opinion is what the board should rely on, as there hasn't been another one submitted. Part 2 of my presentation was...
I just had a...
No, please.
You're going off the valuation, or are you staying on the valuation question? Or?
I was going to move on from
Okay,
the...
I just wanted to say something on the valuation.
No, please.
Yeah, I mean, I've lived in Nottingham my whole life, and believe me, I've never seen anything that ever drops my valuation. Never. I hope it does sometime, but nothing ever goes down. So, I listen to the racetrack. It runs every Friday night, all summer, and some nights it's noisy, some nights it's not. But I just want to let that since the racetrack's been there since the '60s. My father actually built it originally, and we sold it in '83. But the racetrack sits there, and over probably 500 or 800 houses, maybe 1,000 houses have been built around that racetrack over the years. They're just building new houses on Kelsey Road, and believe me, that's not far away. That's one of those houses they're asking $600,000 for. So I don't think the valuation, I don't seem to think that the racetrack is affecting. As far as Tamarack goes, Tamarack is really like right on top of the racetrack. It really, I mean, there was a development, they built it, they put houses in, people knew the racetrack was there, they bought them, and it's right on top. It's quite a bit of a different story from...
but they're not quarter-acre lots. Lee doesn't allow quarter-acre lots.
No, they're full-size lot, but they bought a 125. I mean, I've been in that development. It's noisy, even when the racetrack isn't running. So, okay, go ahead.
One last point with respect to Mr. Reynolds' comment. In my review of the footage from the last meeting, I think he was actually quite upfront that there is noise associated with watercross. I don't think he ever tried to hide the fact that this is an event that does generate noise. I think his position was that it doesn't generate more noise than an active gravel pit that runs all the time. And if the question is about noise, I think the variance would actually work in a way that it would reduce the constancy of the noise from the property. Nottingham, as I put in my letter, is not a town with a noise ordinance. There's no parameters for measuring receptive noise on a type of property and determining whether that receptive noise exceeds a certain level. And I think what Mr. Reynolds was saying, I think it was quite clear about at the last meeting, is that there is noise associated with these events, and it's not more than an active gravel pit. And that by granting the variance, it may limit the noise in that one of the conditions my clients are proposing is not to be racing snowmobiles on any other day except for the approved days of the conditions, which would be in the fall, summer, and spring, 3 weekends, Friday, Saturday, Sunday. Right now, it is private property. They can run snowmobiles all the time if they want to.
So Terry, can I make one more point?
As a good faith gesture, they're proposing not to do that.
Yep, go right ahead.
So my concern, sir, was not that there's is or isn't a noise ordinance. It was how this event will impact property values, because we are required as a board to agree, each of us individually, that every one of 5 criteria have been met. And if we think you meet all of those, we have to vote in favor of your application. If we think you don't meet even one of them, we have to vote against it. So that's where we're at statutorily. You know that.
Oh, sure.
So I'm not trying to get off on a tangent about noise. We did that the last time, and it's really a nowhere street. But the noise is definitely significant, and it is, from recordings that I've heard, louder than the gravel operation, in spite of what you said. But anyway, that's neither here nor there.
I understand that the charge of the board under the statute is to consider the 5 factors for a variance and then determine whether the proposed application meets those standards. The only thing I would submit with respect to the property valuation is that there has been an expert report submitted to the board that the board just can't ignore. It can disagree with it, but it can't ignor it.
Well, I do disagree with it, so
Okay.
I wanted to make that clear.
We're going to move on from this.
We didn't get to the water guy yet, George, or
Well, the
whatever.
water,
So
does anybody have
Mr. Holt is
questions?
here, if anyone has questions for
Anybody
him.
have questions? Because if not, we're just going to, I mean, it's in the record, we got the report. We've
Otherwise,
read
my
it.
understanding is
It's going to be in the record, so
Limited time tonight, right? Yeah, okay.
does anybody have any questions?
Questions on Mr. Holt?
Yes.
Mr. Holt's hydrogeological report.
No, I have none.
Kevin, do you?
Honestly, I'm still quickly reviewing the report, so.
Bonnie,
Yes,
do you have questions for the,
I do not,
you do not?
no.
Okay.
I think you can probably stay around for a little bit while Mr. Bassett continues to
Okay.
read, and I'll continue droning on. I'll quickly go through the variance criteria, like I said, just to make sure we hit every base before rounding home. It's certainly not my intention to lecture the board about the particulars of RSA 674-33. I'm going to start with unnecessary hardship, because I find that question generally garners the most interest from municipal boards as well as abutters. The hardship standard asks whether literal enforcement of the variance will result in an unnecessary hardship for the property owner. While unnecessary hardship can and has been viewed through many lenses, the lens that we're looking to apply tonight is the first definition in the enabling statute of RSA 674. And that fundamentally involves a 3-part test. The first part is that there are special conditions of the property that distinguish it from other properties in the area. Second, that no fair or substantial relationship exists between the general public purpose of the ordinance and the specific application to the property. And finally, that the proposed use is a reasonable one. We are not examining, for instance, whether the property can reasonably be used in strict conformance with the town's zoning ordinance. That's a different factor. So starting with special circumstances, this property is uniquely suited for this type of event. I know that the board has heard this probably countless times before. It is a massive lot of approximately, or two lots combined, of 88 acres. The next largest property is 41 acres. I think most of the abutting properties combined would actually fit within this lot. Second, there is a sizable and substantial pond uniquely suited for this type of event. If any of the board members have taken my client's offer to see the view of the property, it is screened, it is wooded, and the forest there provides sound dampening that would alleviate concerns about noise. And finally, it's an active gravel pit. This property, while in a residential zone, is, for many intents and purposes, industrial. Gravel pits are noisy, dusty, nuisancey, if that's a word, operations. And we're not proposing to hold this in some prairie or field that people come and look at. We're planning to hold this in a gravel pit. And I don't think that can be lost here. So what I would say is that, given the substantial size of this property, the configuration of it, the pond, its historic industrial use prior to Nottingham zoning, the property is uniquely burdened by the ordinance compared to other properties in the area, and that this property, can't support a residential use. It just can't. So those are the special circumstances of the property at issue here. Finally, or moving forward to fair and application of the zoning ordinance, again, this property is zoned in a residential manner. But it is hard pressed to say that this is a residential area, Mr. Bassett.
I believe there was discussion in past meetings on why this is zoned residential and not commercial, or not pursued as being rezoned as commercial. Could you just review?
To be honest, I am not aware of the history as to why the town zoned the property residential, or why it zoned the property or not commercial. What I do know is that it is very uncommon, if not exceptionally rare, to see an active gravel pit within a residential zone. A gravel pit in a residential area is antithetical to the idea of a residential area.
If this was actually zoned commercial at this time, would you be before the board?
My understanding of the town's ordinance, I would not be.
Okay.
But I'm not here to rezone the property. I would have to go to I think I'd have to go to the select board for that.
Understood.
I have a question, Terry.
Yes, go ahead.
Sir, Brian?
Yes.
May I call you Brian? Could you please explain to me why you made the statement that this could not be a residential property, or it could not be developed residentially, because that is one of the permitted uses in the ordinance.
It is, so a part of it is a residential property. But what you're dealing with the situation is it's our position that you can't turn an active gravel pit with a pond in the middle of it and a property of this magnitude into any type of meaningful residential use. And I'm not saying that is the end-all be-all standard here. It is also that the property is really specially suited, given its unique characteristics, for this type of event.
So the ordinance does permit many uses in the residential zone, which include single-family residences, duplexes, multifamily, up to 6 units, seasonal dwellings, farming and related agricultural uses, and so forth. So I know that the town of Lee, I just know Lee because I lived there and I had a business there. The whole center of the town is a gravel deposit. It's supposedly 80 feet deep, and I think it makes for great septic systems.
I'm not in a position to...
Anyway, so you don't really, you're just saying because of the gravel operation, it wouldn't be...
I'm saying that because of the gravel operation, because of the size of the property, because of his historic industrial use, that it is more appropriate to use this property in an industrial sense that it is currently being used at, than one that is strictly residential.
Okay, you all done, Bonnie?
Yes,
Okay.
for the moment. Thank you, Terry.
Go ahead.
As I was saying, there's no fair and substantial relationship to the application of the residence zone to this property because it is currently hosting an industrial use and has been hosting an industrial use for many years. Not only that, it abuts a major thoroughfare on Route 156. There's truck J braking on it. It's a loud thoroughfare. And not the type of thing that you would necessarily see in a residential area.
Ryan, can I interrupt you for 1 minute?
You may.
To further clarify, the reason they are here is because they went to the planning board for approval for the races, because the Board of Selectmen had approved before, but in order to have it as an annual event, they had to go for a change of use. When they went for change of use for those 3 events a year, the planning board looked at their application and said, you are zoned residential, this doesn't fit residential, so you have to go get a variance for that. That's the only reason they're here,
So,
is because it's events and then,
so I might ask if the applicants are pursuant in the future to get this zone commercial. And
Actually-
it may or may not have
Can I
applicability to this
we're not
particular
here,
decision, but
yeah.
Well, that actually was one of my questions, because in reading the ordinance, there is a provision in it, tracts for special purposes. Specific tracts or portions thereof may be designated jointly by the planning board and the owner after a public hearing for special purposes, including the following. There are a bunch of them, but I'll just read the only one that applies here. Public park or recreational facilities with specific associated commercial enterprises. I mean, to me, that should be where they're at, not here.
All right,
I'm not-
they're
I'm
in here
not-
for a variance, they're not in here to become a commercial piece, so let's just stick with the variance part.
Yeah, I would like to stick with
I
the
don't wanna
variance
get
part,
sidetracked.
and the planning board jurisdiction there is, I think, limited. In sum on the unnecessary hardship, while this property is located near residences, I do not think it is fair to say that the area is residential, given the copious and long-lasting industrial operations that have been occurring on my client's property. We've covered diminution in value at length. I'm happy to continue on with that or to move forward.
Are you done with hardship?
I was, yes.
Because I would like to make a statement about that. So the property is already being used commercially in a grandfathered use, so
Yes, ma'am.
it's an ongoing operation. I mean, nobody's quibbling with that.
Yep.
Additionally, the zoning ordinance already allows them to be using it commercially. The zoning ordinance doesn't allow it, but they are either grandfathered or they have some kind of permission because they're definitely a legal gravel pit. So their constitutional right to earn money from this property has not been squelched. And there are a lot of other things they could do that are permitted in the ordinance. So they haven't been deprived of their constitutional right. However, I spoke with the Wetlands Bureau of the Department of Environmental Services because I was trying to research the history of it prior to this hearing. And they told me that the pond or lake is not a natural feature, was not there prior to 1998, and was created by the gravel operation. So, to me, it seems that using that as a hardship is kind of like me building any kind of structure on my residential lot, and then after a few years saying to the town, gee, I'd really like to have a 5 and dime here, or a pizza joint, or some other commercial use, because now I have a hardship of something that I made that's on my lot. And I tried to find out if there was any case law around that, and there doesn't really seem to be any.
Yeah, I'm not aware of any. The issue of the hardship is that there are special conditions of the property that make it uniquely suited for the use being suggested, and one of those is
The lake,
the lake. Or
But
the
they made
pond,
the
which is
lake.
man-made.
handmade, right?
Yes. And I don't think view those intention.
It wasn't intentionally made.
It was, I believe it was intentionally made, or it's a byproduct of a gravel operation. But I don't view that intention as, I don't view the pond being man-made as being in any way intention with the proposed request for a variance and the demonstration of an unnecessary hardship. You started your remarks by saying, well, the property can be used for other things.
Under the ordinance.
And that's one factor of the variance criteria under the statute, or one test you could use. But we're looking at a different test, and that is the test of owing to the special conditions of the property, i.e. an active gravel pit. It makes no sense to treat this property as only being residential, because fundamentally it is not residential.
But fundamentally, they're not being deprived because they have an active gravel pit either.
But that's a different test under the statute, and the statute enables you two paths to seek a variance and demonstrate unnecessary hardship. One is, you can say, is that your property rights are unduly restricted because of the strict application of the variance. The other is to say that owing to the special conditions of the property, the history of the property, its configuration and layout, that there is no substantive reason to apply a strict residential overlay to this property. And there isn't here, because it frankly is not residential. No one, I think, can argue that a gravel pit is a residential use.
But the zone is residential and agricultural, not just residential. I mean, it's a.
But yeah,
Not commercial. They have a grandfathered commercial use, or
correct.
they have a non-conforming use already, and they're asking for a second non-conforming use in a residential zone.
Correct, and the statute allows them to do that, and it allows this board to grant the variance if the criteria are met.
Right. If.
Okay, we'll go, be pretty close to,
Just very,
you're a little shy of your 4 hours. You're going good.
believe me, I can talk.
Okay.
So I think the only thing I would say is, with respect to the other factors, I'll just focus on no contrary, or not contrary to the public interest and with the spirit of the ordinance. Those two factors are generally taken together according to Supreme Court precedent, and that is examining whether granting the variance would alter the essential character of the neighborhood. We don't think it would in this case, because this is an area that, abuts a major thoroughfare. There's an active gravel pit that's been on the property for some time. The pollution issue that has been raised before has been addressed. And as for the noise issue, this is an area where there already is a substantial amount of noise generated from the property. They're already allowed to race snowmobiles across the pond whenever they want to. We're just requesting that we formalize it in events, and as part of that trade-off, my clients have agreed to only do events 6.5 days, thank you.
6.5 days a year.
6.5 days, Friday, Saturday, Sunday, but Friday's only from 2 to 4. In the spring, fall, and summer, and that is part of the condition. They won't, be operating snowmobiles on the water, except for during the events. So from that frame of mind, there is no way, from our position, that granting the variance would alter the essential character of the area, or would be injurious to the public welfare. And with that, with Mr. Chairman's permission, I would just save my concluding remarks, very brief concluding remarks, it's under a page, for after public commentary, so I can just address any comments that do emerge. With your permission, sir.
Regarding the water testing.
I do not.
Okay, yeah.
One concession that was made in a previous meeting was a fence was possibly going to be constructed
We talked about that in the
at some
planning
point in
board.
time.
I'm not aware of that, and that's something that the planning board could take up and impose if it wants.
It doesn't appear as though there's any questions for you.
Mr. Chair, may I make a statement, please? Michael Saylor on 12 Indian Run. Before
Oh, wait,
Mr. Holt
leaves,
I have some questions for him later on, asking that he remain here, so he
Gonna
has
have,
questions about this witness.
I would just comment that this isn't a the cross-examination
No,
type
it isn't.
format.
No, this is,
I believe in your remarks, Mr. Chairman, you said that any questions that we raised to you.
right. Okay, any other questions? Okay, anybody else to speak in favor of this? But something new, it has to be something new.
Excuse me, can I speak?
Did you testify before?
I have not.
You haven't at all?
I actually
What's it pertaining to, somewhat?
I own 212 Raymond Road at Unit 4.
Okay, well, you can come up, okay.
Yes, you do.
Yeah, you can come up and sit right at the table and speak into the mic, state your name and where you're from.
My name is Susan Montigny. I reside at 212 Raymond Road, Unit 4. I have just put my condo up for sale. The noise, you shut your windows, you turn your TV on, you cannot hear these snowmobiles, okay? The two complainers from the property do not own the property, are not property owners, do not pay property taxes. This is just a waste of time, guys. I mean, we had people looking at the house today with a child that had no problem. So for somebody a mile, 2 miles away complaining that it's a problem, it's really not.
Thank you.
So,
Okay, you.
Thank you.
thank you.
Okay, we have anybody else with something new? Okay, so now we're gonna have the people that are opposed to this, that with something new, can come up and address it. Please, just state your name and where you're from.
Sorry, technical difficulty.
Okay. You gotta stick with new stuff, 'cause
New stuff, brand new.
we had you. for
Michael
quite-
St. Laurent,
we
12
had you
Indian
for quite
Run.
a while, Mr. St. Laurent. so-
Sure, well, we have a report by Mr. Holt, is it? Correct. The questions I have for him are, first, is he an expert in the emissions of two-cycle snowmobile emissions, the air emissions? So I'm supposed to ask through you to him?
Right, and you're up here now, and you could ask him a question.
Sure. So the questions I have, are you an expert in the air emissions of two-stroke snowmobiles?
So, I'm George Holt, Areas Engineering Principal.
You can sit at the table if you want.
Yeah.
You can move over a little if you want. Just so the mic picks you up, that's all.
Principal hydrogeologist at Areas Engineering. I have been working in New Hampshire since 1992, environmental, and prior to that in Oregon. I would say that I've 32 years that I've been in the environmental field. Our work, I'm mostly groundwater. However, we do air dispersion modeling as part of our work. We have worked on a number of air modeling projects, which would include industrial discharges. I have not specifically worked with snow machine air discharges, but I would say that they are not dissimilar to discharges from other personal watercraft or two-cycle engines.
Okay. So my next question is, have you calculated, based on the estimate that the event producer said to me, that the people that do the events use about 2.5 gallons per fuel. So about 250 gallons of fuel are used by two-cycle motors, and those two-cycle motors are about 70% efficient. The ones that are stock and modified ones, I understand, are better than that. So basically 30% of the gas out of all the modified units, not modified units, is expelled in a plume into the air. And what happens to that 50 or 60 gallons of gas?
Mr. Chairman, if I may, I want to be cautious here of this evolving into what in my world is an expert deposition.
Right.
If Mr. St. Laurent wants to state his his own expert qualifications on air emissions, and I don't mean that pejoratively. If he wants to state his own qualifications and state his own theses and reports, he's entitled to do that, and Mr. Holt is entitled to rebut them. Or if the board has questions that...
Well, let me rephrase my question then.
If I may finish. If the board has questions that emanate from his statement, then certainly, but I want to be cautious here with your leeway.
Right, I don't want to-
An expert deposition.
I mean, he's got a report, he's, you had a right to bring in, I mean, you could have had some
Correct.
expert.
So let me rephrase the question then. Please explain to us how the gas that is not burned by two-cycle engines, how is that dispersed and disposed of? When it goes into the air, that's a common thing that people know. They see the cloud, they see the emissions of all this gas and oil and toxic chemicals. What happens to that?
But I would again say that you're going down the same, if Mr. St. Laurent has a statement that he wants to make about air emissions, my opinion, I'm not the board's attorney, is that he's entitled to make them, and Mr. Holt is entitled to rebut them appropriately.
Right, I think Mr. Holt covers most of that in his report, so, I mean, you could have brought in an expert of your own, so you didn't. So-
Correct.
The other concern is that we're here for a specific variance, and I don't recall that the gasoline emissions from the snowmobiles was part of that.
We already heard, Mr. St. Laurent went on and on about the gas. I mean, you got a gravel pit, you got diesel fuel, you got diesel engines, you got trucks going in and out. I mean, they
Yeah.
produce a lot too. I mean, you live on the lake, I'm sure those motorboats,
Okay.
they're probably not efficient.
Well, if I'm not allowed to ask questions, I'll
No,
just...
but I'm just talking,
I'll just make
you've already
some...
gone over a lot of this stuff, so I think he's,
Well, no, we haven't gone over that, sir,
Well,
I'm sorry.
if you wanted to bring something in, you could bring your own
Okay.
expert in, so.
Well, I'd like to thank you,
Just,
Mr. Hall.
if you
I
have
appreciate
questions
your
about his
time.
report, you could ask, but don't
Yeah,
go off into,
okay. So, I'm all set with you, thank you very much.
Thank you.
Thank you for your time. The attorney expressed a concern that there were people at the very beginning of his argument, that there were people that were not able to contest the previous meeting. So I'd like to make some corrections to that because he was incorrect. There's some false statements. I sold my house in Newmarket on July 23rd. I have had a certificate of occupancy since 2005 in Pawtuckaway on my home in 12 Indian Run. I've been a taxpayer for 7 years. I contend that my property is 7/10 of a mile from the road where the noise is expelled, which is a different way of looking at the law, but also that only 4/10 of the mile is trees, and the rest of it is water. When my neighbor, Tom Duffy, everybody knows, sneezes, I say, "God bless you," and he says, "Thank you." He's a quarter of a mile away. Mary Covert is a year-round resident that bought her home 2 years ago in 14 Indian Run. She is, yes, a year-round resident. The point is the mother of the owner of the condo. So I just want to make sure that people understand that I'm not a disingenuous person. I've been coming to Pawtuckaway 30 years before this young man was born. I have kayaked every single inch pretty much of this lake. I run up and down the mountains dozens of times. I spend all my time outdoors on my camp, and which is now my year-round home. So I'm not disingenuous at all.
I think what he was saying was you're not,
Yeah, I don't think it's
all that
fair.
close.
Yeah, yeah.
You're not in a butter. You don't probably really qualify.
I think your remarks were
Well-
disingenuous to call you.
Did you get a notice when this went up?
No,
Were you on the abutter list?
not in the butter
you weren't on
list.
the
but
abutter list, right?
Yeah.
Okay, go on.
So in the a question I have for you is they've referenced specific sound testing in this meeting, but it is not presented to the board tonight.
That there was no sound
There's
ordinance.
no noise ordinance.
I'm sorry, say again?
There is no noise ordinance in Nottingham, so the sound issue is not something we are able to put up against any standards to discuss it. If you can say it's loud, we get that, but there's no standard by which we can measure the noise and say that it doesn't meet our standard, because we do not have one.
Correct. Except for the zoning that says you cannot make a nuisance noise beyond your boundary in the zoning ordinances, correct? Okay.
There's not a standard.
So we're not going to be referencing any of the testing that the operator of the event did, so that's not admissible evidence, you're saying?
Well, the testing that the people that are running the event did was actually considered by other people as not valid, and they were asking for other testing to be done.
Right.
But like we said, there is no standard, so we have nothing to match it up with.
Okay. Good. I'd like to just finish up with just, I'm not sure if I said this last time, but forgive me if I have, the Aquifer Zone Section 4 Use Regulations, page 10, which is 4C number 2. Prohibited uses, the following uses are prohibited in the Aquifer Protection Zone, except where permitted to continue as non-conforming uses.
Can I stop you for a second? If you'll excuse me. It's my recollection that there's a clay bottom to this pond and it doesn't interfere with the aquifer. Am I wrong on this?
Okay.
Didn't we already discuss this at one time?
I believe so.
Clay, there's a clay bottom in the, in the pond?
Communication between them.
I'm just talking about the law, that the ordinance at this point. Thank you for the information, though, for clarifying that.
I thought we discussed this in one of the earliest meetings.
Several times.
He's only,
I
he's
don't
quoting
believe
the
we have,
ordinance.
But prohibited uses include on-site disposal, storage, processing, or recycling of toxic hazardous materials. So in this new use, the storage that is prohibited would be 500 cars or trucks, which is what the planning board is considering. 100 competitors each with 5 to 10 gallon gas containers, which amounts to 500, 700 gallons of gas. 100 snowmobiles with 1 or 2 gallon tanks. When you add it all up, it's about 9,500 gallons of gas and oil, which is all stored on the property. The second aspect is you may not process this gas on the property, which is competitors are mixing oil and gas containers. They take gas, which is a fluid, and they turn it into a gas by burning it, which is by definition the combustion process. Competitors refill their tanks, and I understand that they do that carefully, which is good, but it is still a process of using 250 gallons of gas. And then finally, there's the disposal. When you burn gas in a two-cycle engine, you dispose of it into the air. 30% of it basically goes into the air in a plume that lands on the ground. Whether or not that is safe or not, which is Mr. Holt has said, I totally disagree. However, it is against the zoning and a prohibited use in the zoning of the board that has approved, the planning board approved all these rules.
Can you cite the 30% rule that you just said from a scientific discovery?
Say again?
You suggested that 30% of the fuel
Right.
is not combusted.
Correct.
You can give me a citation from a scientific situation that says that is correct?
The EPA says
Do you have the citation?
I don't.
So it's hearsay
Yeah.
at this point.
Okay, do you have any more? Because you're kind of running into stuff you've already gone through.
Yeah, well,
Yeah,
okay, I
already
didn't get a chance to rebut people in the
couple
last
times.
meeting, so I appreciate the opportunity tonight to speak, and thank you for your time.
Thank
Okay,
you.
thank you.
Thank you. Please,
Okay.
excuse me 1 second.
Go ahead.
When somebody is talking, I know we all have different opinions, but you've got to kind of keep everything under your hat, okay? Because there's a lot of people here, and I know this is a hot topic for a lot of you. I don't want things to get out of control, okay? Like to try and get through this case, because we have
All
two
right, yeah,
others
we're into an hour,
afterwards.
into the hour and 5 minutes so far. Anybody else in opposition that hasn't spoke before?
No,
You didn't speak before?
no.
Okay, what was it pertaining to?
The noise.
The noise, okay,
Again, my name is Carl Munn. I live 111 Nottingham Road. I am an adjoining to the property. I did submit to the board a paper on the effects of the watercross noise. I do want to correct a couple items that were made falsely, both by a lawyer and some other people that, again, in this report, if you read it, the noise level of recreational snowmobiles, there are a number of reports that, everything I took from this was from data from actual third-party investigations and reports. That noise level is 84 to 97 decibels. Again, the heavy-duty construction equipment runs 80 to 120 decibels. That's also in the report that shows different people that have measured different types of equipment, what that sound level is off of that. So I want to correct first that the false statement that this is the same level of noise as what would be in the gravel pit. It is not, okay? We have in this also showing that performance snowmobiles run at 140 decibels. Again, this is a logarithmic scale. The backup alarms on standard equipment that you hear are 100 to 110 decibels. Living next to the gravel pit, I hear the sound if it's a quiet day, but again, the rustling of the leaves is louder. This event is deafening, and because it is 140 decibels, again, that's 100 times the sound level of the gravel pit. And that's why you see people that are very far distance away complaining about noise, but then this event, you have residences that are right within the area. So one of the statements that was made is this is suitable for this area. And again, in this report, I show the actual data from the different people, or different surveys and different type of reports that were made. Use that data through the calculations that provide. And there needs to be a buffer zone of 1,000 feet to get down to a safe level noise. That is, I've worked for many years as a licensed professional engineer in manufacturing and maintaining noise levels below the OSHA standard of 90 decibels. This will be above the OSHA standard of 90 decibels. It is considered dangerous noise levels for anybody within 1,000 feet. So you have residents, if a child goes outside and he's playing without hearing protection, he could suffer permanent hearing damage for that. And again, you know, if you look at all the data that's in here, it lists that, you know, the different health agencies list that 1 out of 10 people in the United States have some type of hearing loss, whether it's ringing in the ears or not being able to hear certain frequencies. We don't protect ourselves enough from loud noise, you know, whether it's chainsaws or anything. We don't protect ourselves as a society. So you have a large number, millions and millions of people that are suffering from hearing loss because of these type of events.
Okay,
So saying it's suited.
We've heard a lot of this in other testimony.
But the point I want to make is that you're not just subjecting noise, that this is a dangerous noise level, that there will be residents and families that live within a dangerous noise level that the safety, the national and state local agencies are saying should not be subject. That is, people should not be subject to that type of noise level without hearing protection. And so you're forcing residents to have hearing protection.
All right, thank you.
Can I ask a question, Terry?
Yeah,
Did you?
She's got one
Sir?
question, please.
Did you submit your report to the board? Because I haven't seen it.
Yes, I did.
Do you have it, Terry?
I didn't see it, no.
Yeah, I have a record that it was.
Did you submit it
received.
when? Recently?
It was after the first one.
After the first hearing?
First one.
The first hearing, yeah, it
It
might
was on the
be.
website? It was on the website.
Yeah, it was on the website, so, okay. Anybody else? Okay, you haven't spoke before, right? You haven't?
Correct.
Okay. State your name and where your address. And
Pam Kelly, 35 Saks Road. I do have a copy of my statement here, just to enter into the record at some point. I don't want to talk about noise or diminution of value or any of those things. I think that they've been argued about enough, and I think it's so subjective that I don't think I could address it. But I would like to talk about the issue of hardship. And I think that what we really need to think about in terms of hardship is hardship not to the public in general, who's going to be deprived of a wonderful activity, an event that they all enjoy, but the hardship to the applicant. And that's the hardship that has to be proven in order for one of the 5 criteria to be met. And obviously, all of the criteria have to be satisfied. So it sounds like the applicant wants to conduct a watercross business on the property, and existing laws don't allow this business in a residential zone. The property, they argue, is perfectly suited to a watercross business and uniquely suited to a watercross business, maybe. And if it's not allowed, then the applicant says it will constitute an unnecessary hardship because there's no other place that's just as good in the area. And, you know, maybe there's one in Fremont or something, but they want to have one here. So setting aside the accuracy of that claim, I want to focus on the assertion of hardship, which must be proven. Hardship is defined as a condition that is difficult to endure, suffering, deprivation, oppression. In other words, there must be some sort of potential or actual loss that will be experienced by the applicant if the variance is not granted. The loss must be personal to the applicant. In other words, if you read any of the Supreme Court cases on this point, you will see that the hardship must be one that will be experienced by the applicant, him or herself, not by some friend or fellow watercross enthusiast. Also, the hardship is not one that might affect the public in general. Watercross is not a public service. The issue is not whether it's a hardship to members of the public, and by asking the ZBA to consider that watercross businesses cannot be held elsewhere in the area and that this one is uniquely suited to watercross, the applicant is asking for the focus to be on members of the public and not the applicant. So, whether a watercross business can be conducted elsewhere is totally irrelevant. The zoning board must examine how the denial of a variance will cause a hardship to the applicant. Is it that the property cannot be used for any other purpose, which is a common complaint in a variance request? No, because it's already being used as a successful sand and gravel pit and has been for many years. Is it that the applicant will suffer a financial loss from not being able to expand an existing business? And that's also a common theme in these cases? No, because the applicant is not seeking to enlarge the gravel pit, but to start a completely new and unrelated business on the same property. Is it a hardship then that the applicant wants to start this entirely new business? The property is well suited to this business, members of the public want this business, but the zoning laws are standing in the way? If you want something and cannot have it for some reason, how is that a hardship? Is being deprived of wish fulfillment and fun a hardship? What loss will be suffered by the applicant? The property is already in full commercial operation as a pre-existing non-conforming use. This is not a car dealership that needs to add space to remain competitive. It's not an apartment complex that cannot survive financially without additional units. There is no request here to enlarge the existing business as with those Supreme Court cases that I just mentioned. I submit that without a finding of hardship that will be experienced by the applicant, other than not getting to start a fun business, the application for a variance must be denied under the law. And please take a closer look at the requirement of hardship, and I think you'll find this application does not meet the requirements of the law. Thank you.
Okay, thank you. You want to present us with your testimony? Or
Yeah.
You can bring it, give it to them.
Thank
Okay, anybody else, anything new? Anybody else, opposition? Okay, so go back.
I'll be very brief. Thank you. Just 1 second to check something. Does anybody have a copy of my letter? I know I
I
can't.
do. Here.
Thanks.
I just needed to know your name, Brian, so.
Fair enough. I just want to check something.
Actually, you can have that because I have another.
Okay, very good.
Yeah, we were given 2 each, I think.
Always good to have a spare.
Yes, because Kevin provided us with one, and then he brought one, so that's how come we get two. Actually, I have three, because I wasn't home.
Thank you.
Okay, so let me just do a quick rebuttal. With respect to Mr. St. Laurent, I was not calling you disingenuous. My argument was that the idea that you have standing as an abutter was a disingenuous argument. My wife is Jackie Jordan. She went to Newmarket High. She speaks highly of you. I'm not calling you disingenuous. With respect to Mr. St. Laurent's arguments that this is going to involve the storage of fuel, this is not the type of storage of fuel that is contemplated by the ordinance. Those are storage tanks at which there has been plentiful litigation in New Hampshire about. Nor is this the disposal of solid waste. The statute, or excuse me, the ordinance actually references a statute, 149M, and those are actual transfer stations and junkyards. This is not what we're proposing here. With respect to Mr. Munn's comments, I am not a scientist. I think he did say that it has to be 1,000 feet to operate safely. I believe that the closest abutter here is over 1,000 feet, which is what I was checking in my letter for. Regardless, the snow machines are allowed to operate right now, with noise not being a concern for zoning, because this is private property and they're allowed to have practices on the property if they want to have that. What my clients are trying to do is have an event, and the trade-off they're trying to make to be good people is to not run practices except for during the events. So is our position that it would actually limit the amount of noise. And finally, with respect to Ms. Kelly's comments, the definition of hardship that the board needs to focus on is the one in the statute. Ms. Kelly may have been referencing that. It wasn't clear to me that she was. From what I understood, she was referencing cases that may no longer be good law, as the variant statute was amended in 2009 and I believe again in 2018. And that statute very specifically defines what a hardship is. And that fundamentally is that owing to the special conditions on the property, there's no fair application of the ordinance to the property. We believe we have that here. Because this is an industrial use, it does not fairly make sense to apply a strict residential overlay to this property. And finally, in my closing remarks, if you are a member of the board who voted for the variance application in June 15th of this year, from our perspective, there is no reason for you to deny the application now. Fundamentally, nothing has changed. No new information has been presented that should cause you to deny the variance. In fact, I think the information that has been presented, the new information, all leans towards the board granting a variance. And that includes Mr. Holt's report about potential pollution and address questions that were raised by the board. And it also includes Mr. Lavoie's expert property assessment that granting a variance will not negatively affect property values. And finally, if you are a board member who voted against the variance, we've tried very hard to answer the questions that you had raised in June of 2000, excuse me, I keep saying that, June 15th of this year. And that includes addressing particularly Ms. McKinnon's question as to whether or not the operation of watercross events would affect people's well waters, and we've demonstrated that it will not. So for those reasons, it is our position that this board should grant the variance, that we meet all criteria for a variance. I thank you for your time, your patience, and your consideration of this matter. And my last comment is that, all the documents online and in the record, I would just incorporate those into the hearing by reference. And thank you.
Thank you. Any questions by the board? Any? Okay, so we're going to close the hearing and we'll discuss it, or? Okay, so it's closed. We've heard all the testimony and we can discuss it, make motions, do whatever.
Mr. Chairman, barring no questions from the rest of the team, I move we accept the application from Tammy DeFrancesco and James George as written.
Second.
Okay, there's a motion and a second to accept the application for case 21008 VA as written. So any discussion on this? Okay, so all those in favor?
Can you repeat the motion, the application as written, so we know what the motion includes? Please?
The application is for a variance from Article 2, Section C of the zoning ordinance to permit watercross events with incidental camping, parentheses, i.e. commercial use, parentheses, 3 weekends per year. The property is located at 214 Raymond Road in Nottingham and is identified as tax map 69, lots 8 and 10.
It seems like last time you had a thing in about no practices, except on those weekends.
Those are something we can put in, but that's,
They've already said that they were not, like, it's not part of their application.
right.
No, but we can place restrictions. I thought we did the last time, that's all.
No, that was what they,
I didn't, but I.
no, we didn't, no.
And I don't know, maybe the planning board has talked with them about that, but I don't remember doing that. I apologize, Bonnie.
No, it was a straight motion, so. I think that was after we did that, and they came in and talked. Okay, so we have a motion and a second. All those in favor of granting the variance, say aye, raise your hand. Aye. All those opposed? Okay, all those opposed?
Me.
Okay, so it's four
I don't believe it meets two of the
yes,
5 criteria.
1 no. So that, it passes, and, but you guys are in the planning board, I mean, the variance, it can be appealed to the Superior Court in 30 days, so, you know, but you guys are before the planning board, so you're probably gonna be a while anyway, so. Okay, we thank you all for coming. Thank you. See you.
Whole house.
Was full.
I'm asking that you all please leave quietly because our meeting is going to be continuing with our next cases. Thank you.
Keep moving out of the hallway, that's for them.
Okay, our next case, this is case B, it's 21-00011 VA, it's dash VA, application from Richard and Mary Ellen Cody for a variance from Article 2, Section C1, to change the use of 1 unit to unspecified office. The property is located at 18 Cooper Hill Road and is known as tax map 16, lot 5. Okay, can you state, who's gonna,
I can present it. Yeah. Scott Franklin.
you're Richard? Are you Richard?
I'm Richard, yes.
Okay,
Scott Franklin from New Hampshire Land Consultants.
okay, so who's gonna,
I can go through what our request is real quick if you like.
yep, go ahead.
We did go to the planning board and they sent this to here because they felt we needed a variance for a office use within a residential zone. As you said, this is, property is located at 18 and 24 Cooper Hill Road. It's the old mill condominium development on Cooper Hill Road, about just under 1,000 feet from Route 4. What we're proposing, initially, the Codys looked at doing an apartment in this building. We talked to the building inspector, and he said that wasn't a good use. So they've decided they want to do an office space within this building, renovate it to be usable office space. There's a new foundation under the building. It's been on the property since it was the mill. They started renovating it, and they'd like to put the building to use. When it was approved as a condominium, this was limited common area number 6 on the approved plan that I believe was submitted. And this was considered as storage, as well as the larger building under the limited common area 6 is also storage. There's a couple parking spaces that were designated for this on the condominium plan. And so the variance that we have in front of you is to allow an office space within a residential zone.
Okay, any other, do you have anything, you're good?
Well, the one thing that you might have left out is that it actually was called a multi-use building. So storage and multi-use building, on the large building of the two on that
Okay,
limited.
so it's the bigger of the two, because it was 2 units, there's The Unit 6 is the one closest to the leach field, the larger building, right? That's the one you're gonna do.
No, I went to the little one,
You're going to the little one.
400 square foot
Over on
one.
the other, in the
Right,
back.
Right.
Okay, because it wasn't clear in your thing which, so you're gonna go with that 400 square foot
Right.
in the back. And you are in a commercial zone because you come in off of.
The property is, and that's why we're here, the property is actually zoned residential, but we're within 1,000 feet of Route 4, so it's not, in your regulations, you have to have frontage on Route 4 to be considered commercial.
Right.
And this doesn't have frontage on Route 4, so it's residential, but we're within that 1,000 feet. So
Right,
it's
you
kind
are
of a
within
weird-
the, you are within the
weird
zone.
zone.
And I drive by there all the time. You're saying it's the one, the further back, not the one that's the roadside?
Right,
Yeah,
it's
the
set
little-
in, yeah, yeah,
Okay.
yeah, yeah.
Yeah, because I went by a couple times and I see there's a little one back.
Did you wave?
So
I did.
so the one at the roadside, do you own that one also?
Yes.
And it's, will remain apartments?
Yeah, those will remain, those, there's no change there. The only change is that one little 400 square foot
Shed in the back?
building, yeah,
So that will remain storage, just like.
The larger one.
the larger one will.
Yeah.
Yeah, and then the small one would just turn to an office.
Is this gonna be an office for rent, like maybe a real estate company, or?
You know, we don't really know what would go in there. It could be like a insurance agent, or it could just be an artist that wants to
Okay.
paint something and put, and sell something. It used to be a little kilt shop at one time. They actually
Remember.
sold kilts out of there. But, we're open to see where it go. Our objective is to get the building at least renovated and find some use for it. Either,
There were renderings submitted, I don't know if they were submitted to this board or not, of what the Codys would like to do with the building. They were done by All in Media in Northwood. They do renderings for residential and commercial developments, and it kind of shows what they like to do. Of course, we have to go back to the planning board after this for a change of use. At the first planning board meeting, they had some comments that we'll have to address, and we'll address those if this is
Right,
approved tonight.
Is there other question?
yeah, can you review what the 1,000-foot
So
means?
So in Nottingham, on Route 4, you've got a 1,000-foot commercial zone, but in the regulations, it says if you're fronting on Route 4. So even though this property is within 1,000 feet of Route 4, it's not considered commercial because there's no frontage. This property doesn't have any frontage on Route 4.
It's just up Cooper Hill a little bit,
Understood.
Okay.
Okay.
not very far at all.
Go through the criteria, please, with us.
Yep. So number one, granting the variance would not be contrary to the public interest. The 400 square foot detached multi-purpose building has existed for over 80 years, long before most buildings in the area. It is set in a way away from the street. Changing its use to unspecified office will have no adverse effect on public interest. Number two, if the variance were granted, the spirit of the ordinance is observed. The buildings, Unit 6, were designated as multipurpose in 2007 because they sat within the commercial/industrial Highway 4 corridor shown on the zoning map. Granting this variance would not threaten the public health, safety, or welfare. Number three, granting the variance would do substantial justice because the detached building qualifies for grandfathered status per Article 2, Section C1C. It was in the state of decay and about to collapse when we purchased the property. Foundation now installed, the detached building should be restored and occupied for its best use as office space. And note, at one time, it did operate as a kilt manufacturing retail office space. Number four, if the variance is granted, the values of the surrounding properties are not diminished because this building has existed as part of the mill that goes back 100 years. Its refurbishing will improve the look of the property and only increase value of surrounding properties by having a well-maintained neighboring property. Number five, unnecessary hardship. Owing to special conditions of the property that distinguish it from other properties in the area, denial of the variance would result in unnecessary hardship because no fair and substantial relationship exists between the general public purpose of the ordinance provision and the specific application of that provision to the property. And the detached building was not occupied and not structurally safe when we purchased the property. We were issued a permit to raise and construct a foundation under the building. We made a substantial financial investment to prevent the building from collapse. We discussed with the building inspector at the time in 2015 that our intent was to restore the building. There were no concerns nor red flags discussed about its use. We have been advised by staff the Unit 6 would most likely not be approved for a residential use. The variance to allow office would not alter the character of the property nor the character of the neighborhood. And the proposed use is reasonable, one, because the proposed use of Unit 6 detached building as unspecified office, because it would have little to no impact on property and neighborhood. And B, explain how, if the criteria of subparagraph A are not established, an unnecessary hardship will be deemed to exist if and only if, owing to special conditions of the property that distinguish it from the properties in the area. The property cannot be reasonably used in strict conformance with the ordinance, and a variance is therefore necessary to enable a reasonable use of it. Sometime back in the late 1900s, this property was converted from an operating wood mill into 5 apartments, horse stalls, later a shop and storage unit, in the multi-purpose buildings, and a manufacturing and retail sales of Scottish kilts by Richard Lyons in the detached building. In 2007, the units were converted into condominiums by Paul Longo, with 5 residential units and 1 multi-purpose building. The multi-purpose building existed as LCA Unit 6, exists within the town of Nottingham zoning map corridor Highway 4 Commercial Industrial Zone. The hardship is that we invested approximately $10,000 to put a foundation in under this building with no use unless a variance is granted. We were advised that the best use of this detached building would be to leave it commercial and change the use to office space. As you can tell, those arguments were written by Mr. Cody and expresses his
What does LCA mean?
limited common area.
Thank you.
It's really, a lot of times, they're just around the buildings. It's a limited common area where if you're in a condominium, only that Unit 6 will have use of that area.
It's good when you use abbreviations to at least say what it is once, then use the abbreviation.
5A, advised by staff that Unit 6 would most likely not be approved for residential. Staff is who?
Building inspector, we spoke, I believe that's what you were referring to.
Yeah. And the reason why it wouldn't be residential is just,
There's a couple reasons. A septic system compared, office space compared to a residential use is, office space is 5 gallons per 100 square feet, so you're looking at 20 gallons per day of projected effluent flow from this, if it's office. If it's residential, say it's a 2-bedroom, you're looking at 225 to 300 gallons per day.
okay.
So that's one of the factors I think that the building inspector looked at, is the inability to expand the leach field that much.
Right. But plus you gotta figure in the number of people that are in the office too, right? So, I mean, that's not just 5 square foot. So, does anybody else, I don't wanna, anybody else have questions? Because I have some, but if anybody else, can go first.
I was going to ask the same question that Kevin asked, like, who told you it wouldn't be residential? So that was
Okay.
it. That was the only,
Okay, I just have one question. How many bedrooms are in in all those condos? Are they 1 bedroom, 2 bedroom, 3 bedroom?
There is a breakdown on the septic design that Bill Wormel did.
Right there.
Oh, I see it right there on the left, yeah.
Yeah, bottom left corner.
Yeah.
So there's 5 bedrooms in building B and 4 in building A.
Okay, so you got 9. Have you done lot load? I mean,
Yeah, there's,
not much, I mean, not a lot there.
right, and the expansion will be minor, and hopefully, like a lot of towns do, as you probably know, you kind of have a pocket approval where you get it approved for expansion, but you don't expand it and improve it.
Right,
unless you
until it
have.
fails.
Right, and hopefully the building inspector will agree with that. But with the minor increase in flow, there should be no problem with the loading. I can't remember the size, what's the size of your lot?
The lot,
Yeah,
acre-wise?
just over 2 acres.
Yeah, it's 2.2, I think.
Yeah, but there's a lot of,
A lot of stuff going on there. And that will be part of the,
Plus, it's closer than, you didn't ask for any variance on the wetlands?
for,
Well, I mean, you're supposed to be like, what, 50 feet? I mean, I know it's an existing building, but you're changing the use.
right, no, there was no variance. We didn't see any variance needed for the,
Okay, so I just wanted to make sure
Yeah.
while we're here.
and as we go back to the planning board, of course, we'll have to address the septic and all the.
Oh, right, yeah. Okay, any other questions, comments? Anybody else to speak on this?
Does our building inspector have any concerns?
Do you have anything on this, comment on this one?
Again, our role is not to have before or
Oh, you can come right up.
And could you guys step aside?
You can sit there if you want, you can sit right at the end of the table.
Yeah, okay.
It'll make it easier, you got the mic.
Dale Sylvia, building inspector. Our role is not, or my role is not to support or be against any applicant. It's just to enforce what the rules are and what we see, and I'm here tonight to answer any specific questions. I will say that I do agree with pretty much everything that Mr. Frankowitz said. Did I say that right? Okay, thank you. My concern with it being, there were several concerns with it being residential. Septic was one. We were also looking at the lot size versus how many units and things like that. We were looking at parking. There were a lot of issues, and I did not think it would be appropriate or should be the intent of the ordinance to be granted as another residential unit. I didn't think a 6th unit was appropriate. Where this already was an existing business at one time, and it'll be a slight change in use, and the fact that previous building inspectors have granted building permits, and they've done considerable amount of work, and they're not actually proposing to do construction, just change in use, I thought it would be appropriate and does meet the intent for an office space. So the town does not have any objection to what they're asking for at this time.
Okay.
I would want to revisit, or I would ask you or the planning board to revisit the parking situation. I don't believe it's gonna be a problem, and I think there is more than enough parking, but I think it does need to be identified and updated. I don't think that would be a hindrance or a red flag, but it does need to be updated along with this.
It's a planning board issue.
So, do you have any questions for me?
Nope, you're
Thank you.
good.
Thank you.
Okay,
So on
anybody
the,
else?
on the topic of the parking, that's a planning board
Right.
topic and not,
Yeah,
not our
no, we're just
jurisdiction. Okay.
granting the variance to allow them to go ahead, and they'll go before the planning board, and, okay, anybody else? Anybody in opposition to speak?
Can I just ask for clarification? It's not an office building for you, it's space you're gonna be renting out. You're not even on the property, correct? You live in California?
Yeah, our residence is in California.
Okay.
Yeah. We do visit seasonally.
Okay.
Yeah. My son lives on the property.
Okay, and it's, so, but it isn't office space for you all, it's for renting out?
For renting out. yeah,
Okay.
Yeah.
I just wanted to clarify from that.
Why are you staying in California?
Yeah. I thought you would be,
Because I can't get my daughter to move out here.
I thought you were fleeing to this office space.
I know. I'm originally from here, and and I got the calling to come back, and that's why we purchased this property, so we have a home in both places, and I have grandkids in both places, so that's what we do.
Snowbird.
We're like snow, we still come here in the snow, though. Yeah, so we can't officially be snowbirds. My wife likes to shovel, she says.
I have a house that's on the top of the...
Yeah, I know, that's what I tell her, yeah.
Okay,
Is there any limitations on occupancy of the office?
What do you mean?
In other words,
I think the 400 square feet is gonna limit it.
Yeah.
not the space, I'm talking about people.
Well, I think that goes to the planning board, they're gonna look at it, they're gonna look at the septic load, the, size of the building.
But you could put 24 people in there.
Not easily.
I'm just saying, friendly people.
This isn't California.
We're not talking the Texas
Yeah, we're not
border
talking-
right now.
We're not talking California.
Yeah, that's right, yeah.
OSHA itself has, am I correct, size requirements based on space, Dale?
It's,
So for an occupancy load, it'd be based upon space, and each classification of business, depending what type of business it is,
Right.
has a coefficient that you measure, and that's how you get your occupancy load.
Plus the
Okay.
fire department would have a. look
They're the
at
ones
that.
that would actually, in conjunction with me, but they're the ones that would enforce an occupancy on a business load.
So you aren't gonna have 400 people in. there.
However, I've been in this since, as part of this process, I've gone out there, with the proposed use that they have and the amount of space they have, that's not really a concern.
okay. You need a motion?
You gotta close
Well, we
the
haven't
hearing
closed it
first.
yet.
Oh,
We have
sorry.
anybody in opposition? Okay, so I'm going to close the case. I'm going to close the case, and then we'll have a discussion or a motion, so. Okay, so the case is closed.
I move the application of Richard and Mary Ellen Cody for a variance from Article 2, Section small c, parentheses 1, to change the use of one unit to a specified office. The property is located at 18 Cooper Hill Road and is known as Tax Map 16, Lot 5.
Point of correction, it's unspecified office space.
Did I miss
You
that?
said specified, just
My
because
apologies.
it's illegal.
Thank you.
Second,
Okay, we have a motion and a second on case 2111-VA. We have a motion and a second? Okay. All those in favor of granting the variance, please raise your hand.
I will.
Say aye.
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 Okay, so it's 5-0, there's none opposed, so you're good. Yeah, you have nobody was here, but, so I think you're safe. But just in case, there's a 30-day period for anybody to appeal, so.
Okay,
So, don't invest too much money.
no, we'll go slow.
Okay.
Richard, what part of California?
Oh, is it 45 day? 'Cause
Part
I
of San
thought they
Francisco
changed
Bay Area, Livermore. You're familiar with Livermore? It's like,
Wente Winery.
yeah, right there. You're right.
Betcha.
thank you.
I think there's
Okay.
50
And
wine.
Concannon.
Concannon's there as well, yeah, yeah.
I've been there.
Yeah.
Okay, we're on to our.
Out of there.
We're into our last case. This is, says case C, it's 21-010-VA, application from Matt Bergeron for a variance from Article 2, Section C, A, construction with less than 50-foot setback. The property is located at 8 Cahill Lane and is known as Tax Map 68, Lot 49-1. You're Mr.,
I'm Matt.
okay, you're Matt,
Yes. Property owner.
okay.
Do you
Hi, Matt.
Hi.
want to have this read into?
I can't afford to have a surveyor or a lawyer with me, so I guess I'm gonna do this solo.
We could just put this into there was a letter, you want to read it? You can,
We received a letter on this from
Chris.
Chris Sterndale. Board members, I am writing to provide some background on the variance case before you from Matt Bergeron on Cahill Lane. This is an unusual case brought about by unusual events and timing that have created a situation for Mr. Bergeron requiring a variance. With the adoption of warrant Article 19 in 2021, town meeting accepted Cahill Lane as a Class 5 town road. This has created a host of legal questions, surprises, and practical obstacles for some residents and the town government. The planning board and select board have been both actively working to understand and adapt to these changes. Generally, the public has acquired easements that formerly belonged to a limited number of property owners, and those easements are located where roads are shown on approved plans. The road vote took place in the midst of Mr. Bergeron's work on his property and instantly changed the legal framework within which he has to operate. I expect his his application and presentation to you will explain the particulars. In short, he is seeking setback relief from a street that is there on paper, but not in reality. He had previously moved the actual road, then private, away from his home and from its original location shown on plans. Prior to the adoption of Article 19, this permit request would have been approved without concern for setbacks on the then private road. Mr. Bergeron's actions regarding the road have been with full knowledge and consent of the town since 2019-2020. Town staff believe he has acted legally and in good faith throughout, trying to find solutions that work for his location and for the town, all satisfying state DES regulations as well. We tried but failed to find a way to legally avoid a variance request. He, abutters, and staff have all agreed on a proposed solution that would make a variance moot, but this solution would require the approval of the select board and town meeting in 2022. Please let me know if I can help with anything more. Sincerely, Chris Sterndale.
Okay.
So, I think what he's talking about there at the end with the town vote in 2022 is, it's my intention to hopefully take the Cahill Lane portion that I live on, and that now, actually it's my dad that purchased the only house beyond me, and just make that hopefully a shared driveway and no longer town maintenance. But I was told that that would take a town vote. What he's referring to in terms of me starting this process in 2019 is the road Cahill Lane, which is, I don't know if you guys are familiar with it, but there's basically 3 lots on the end of Cahill. Doug Lieb owned these, he subdivided them way back when. And so I purchased the first 2, one has the house on it, and my dad has since purchased the one on the end. So the road went kind of right by my house. And so I approached the town and asked, what do I need to do to move this road further into the woods where I've got all this woodland buffer, and that way the cars aren't coming around right by our bedrooms. And in that timeline, it was the town's position that this was a private way, and as long as your abutters were okay with it, and we got it in writing, and then it was fine. Obviously, it was within 250 feet of the lake, so I had to go through all the DES permitting and all of that, and so I did move the road. In essence, the easement, right-of-way, is what it was called on all the survey maps and stuff, further away from my house. At the same time, I was drawing up plans for an addition on my house, which at the time was, even with it just being Cahill Lane that came right by my house, was at that time, before the warrant article, a private way, which I could be wrong, but I don't think there was any setbacks off of a private way.
No.
So I could have built kind of right up to it as long as that right-of-way still existed for, at the time, Doug and now my dad to still be able to access their property. Got all my plans done, and then as of June, whatever the date was.
28th.
Yeah, everything changed, and now I cannot build within 50 feet of the road.
Right. But
I've got the road on one side, which is no longer a road for all intents and purposes, because Doug, who still lives there, only uses the new way in the woods. And so I've got the old Cahill Lane, which is just basically where I've been parking my cars, and the lake on one side, and now what was this great building envelope that I had when I bought the property has now got a 50-foot setback off of the old Cahill Lane. And so what I'm hoping for is relief from the 50-foot variance off of the old Cahill Lane.
Right, now when the vote, I mean, there was a vote, in June, but, I mean, you didn't object, you didn't remove your, you could have removed your thing from it. I mean, obviously, they must have asked you about
I don't
going
think so.
on there, right?
I actually voted for it.
Right,
I
but I'm
actually
saying-
voted for that. I thought that I was, at
was
the
a
time, I
petition
thought it was
article.
more of a maintenance thing. But could I have So I could have maybe at that time said, I don't want my portion of.
Right, I mean, they
Lane,
must have
so-
asked you, right?
No, because
just
when
got
all
written
of
up
this
without your-
started, I don't think, this was a long timeline in terms of the road discrepancy, and we weren't officially town residents at that time. We were residents of Brentwood at that time. So we've owned this house since 2016, but our primary residence was in Brentwood. We've since moved here permanently as of, I don't know, December, but I think that warrant article was written. But no, I was not asked, would you like
Right,
to
I mean,
be?
because that was kind of like,
I'm also not,
I assume,
Cahill Lane is a lot more than just,
right, but I
my-
assume
my-
he,
my law.
I just assumed everybody was on there. I mean, I was asked, and I said, no, I don't want to be on there, so, but, so now, I mean, now you kind of see the consequences of now you're a
100%.
public road, and,
Yeah,
yeah.
yeah, not realizing that,
But
that
you
meant-
moved your
that
road
meant there was a-
before, I mean, you moved the road before the vote, so.
Correct.
So it's like,
So,
So which is the
and
town?
so that's
road?
confusing too.
That's what the confusing
well,
part is.
isn't that the new Cahill Lane then,
well, that
if
would
it
be
was done before?
Which one is the town road, the old one or the new one?
That's the
There was-
problem that we're running into.
We don't know.
What,
Dale?
wait
Can
one
Dale
second,
answer?
before we go any further, can we just have you do the 5 criteria, and then we
Yes.
can open it up for public discussion?
I don't have a packet on this, like, is there also a map?
It's on here. It's his
Should have been on,
application.
it should have been,
Yeah, but I know I should have it, but I don't have it. Unless it's this one, wait a minute, no, that's Mr.,
I can give you an extra copy.
But see, this was done, I mean, this was,
I don't think it was
the problem
open
you
yet.
have is this was done as a subdivision. It showed a plan on, it showed a road on there.
So the
Even though
reason
it's
that,
private, it's still.
the reason that we're here looking for
Find
the
it, find it.
variance is because
Oh.
we're
I have
considering
2 of these and not that one.
kind of the worst case scenario, that old
2 of the
Cahill
Codys.
Lane is
Thank you, Teresa.
what I need
That'll
to
help
enforce 50
understand.
feet off of. And so therefore, I'm looking for a variance for relief from that 50-foot setback off of the old Cahill Lane.
So where did you, in your drawing, like where did it kind of move to, do you think, on this, kind of over to the edge of that cul-de-sac thing they had there?
Yeah, I can show you, I actually have a.
You kind
I have
of moved
the-
it.
I thought that the DES plan was in there.
Watch rear
Yeah, right.
watching.
So
Trip hazard, big time.
here is the old Cahill Lane.
Yeah, so you moved over.
Here is the new one right up here.
Okay, so you just moved over to the side a little more. Okay.
Are you 50 feet or greater from the new Cahill Lane?
Yeah. Substantially.
So can I see where the new one is? This is the old one?
where do you see the old one and the new one?
This is the old one, right?
Yeah, I don't see it yet either, but he'll bring it around.
This
Well, he's
is-
got a drawing that's different.
Is this your house?
Right.
Yep.
I don't think there's anything in our drawings that shows.
Okay.
Okay, and you,
This is the old Cahill Lane. And
Well, I guess this last page does show.
so it goes like this way and,
yes.
This last page.
All right, so I see
I can
that.
show you
so does your property go to the new one? Yes, it must. Must have gone- This right away went through your property, right? Cut it?
Correct.
Yeah, okay.
Yeah.
Matt, could I see that, please? Or you could show it to both of us.
So
So this is
this
old.
is my existing house right here. This is the only other house at the end of Cahill Lane is way up here. Here's
So,
the,
are we looking at,
Here's the old.
Yep.
here's
There's
the
the new.
existing house
Yep.
and here's yours?
yep, exactly. So here's the old Cahill Lane.
Yeah.
And the new one you can see on this map right here goes like this way. So it kind of cuts out that part that goes right by my house.
So you had approval to
Oh, yeah,
put
here's the
the,
DES plan right there.
yes, you had approval to put in the new Cahill Lane before
Yes.
the vote. So why
Yes.
isn't this now considered the Cahill Lane?
What I was told from Chris was that when the vote took place, because this was a private road and it was the town's position that, yeah, if you and your abutters are in agreement,
There's no setback.
Yeah, go ahead and move it, and you need a shoreline permit, do that. I pursued the shoreline permit, which included notifying all the abutters. The only abutter it affected was the one on the end, because it's a dead-end road. And he was all for it. And Chris said that the town was completely fine with it, but we didn't record anything, so it was the town's attorney's position that when the town voted to adopt Cahill Lane, they voted to adopt the old Cahill Lane, not the new one.
Because the new one had not yet been recorded.
There's no recorded plan for the new one.
Right. And this one, I mean, this was from the original subdivision done by Peter Landry, and that was recorded.
Yes, and I had a plan done for the road, but it was a state shoreland permit plan from Scott Bailey, which you'll see,
Yeah, I see it in the end of
the road permitting.
Yep.
So the problem is that it was Chris's and the building inspector's position that we need to treat Old Cahill Lane as the town road that it now is, and you need a variance if you want to build within 50 feet of that. And so that's why I'm here tonight seeking the.
Sounds like a catch-22.
I know. And then I've got the lake on the other side, which requires 50 feet. So I've got a small area, which used to be a big area.
Now, who owns, your father is on that first section, or he's where Doug Leeb still owns?
No, he's sold. He's
Okay, so your father is out on the end of the
on the
point.
point, yeah.
And then it's you.
And then the one that's vacant, 49-2,
Yeah, that's still vacant?
yeah, I also own that.
Oh, so you own all that?
Yes.
So, I mean, in some ways, I mean,
I would.
your land kind of got grabbed. I mean,
Yes.
if you didn't agree with it, it's kind of like,
I was never asked, do you want to include your portion of,
but you saw it on there
yes,
and you voted for it.
yes, I did.
See, I mean, I think there's going to be a lot of these.
I voted
More
for
of
it.
these over Pawtuckaway than you
Yes,
think.
and I did not understand at the time when I voted for it that I was voting for a town road, which was going to mean 50-foot setbacks. I was voting for what I thought at the time was the town continuing to plow and maintain.
Right, because right now, is that road plowed by the town?
Yes.
Even as they consider,
The new one or the old one?
The new one.
They're plowing the new one.
They're plowing the new one, the
But
old one is like
holding you to
blocked
the old
off,
one.
and part of my DES shoreland permit was reclaiming the old road, which I have not done yet. But it was my plan to revegetate that because it's within the 250 feet of the shoreland buffer. And so they like as much pervious surface area as possible within 250 feet.
I mean, I think you have, I don't know what legal right you, but I would think you have some legal right to say, I don't want that taken by the town. I mean, the whole road is like,
Yeah, and for me, I own on both sides of the road, so what was, now I've got 50 feet on either side of the road that was all buildable and usable, and now is not. So it's,
right, well, I think that's unforeseen consequences of what was done over there. I mean, I think it's not gonna just be you. I think you're gonna see a lot.
that's what I've been told.
A lot of
is
people
that,
affected by this.
I might be one of the earlier ones, but that's what Chris kept saying, is that unfortunately, because I said, why don't we just call this a driveway, and the town doesn't have to do anything with it, and
You'll plow
oh yeah, 100%, but I guess it's not as easy as saying that, so.
it. Well, you got somewhat of an argument. I mean, it's like, they made all these votes, but in a private road, somebody owns like to the middle of the road, and the other person supposedly owns to the middle of a private road, and
Same is true
this
for
person
public
could
roads.
say, I don't want to give up my part of the road, so I mean, there's a lot of problems there.
And in this instance, the road actually goes through the middle of I own on both sides, so in the deed, it says an easement for egress and ingress for the neighboring property, to travel to and from their property, is what it says in the deed. It's a legal right-of-way.
Will you still pursue changing it at town
I
meeting?
would love to take it off the town's hands completely and just my intent down the road, and what I've talked to Chris about is that it's going to take a warrant article and a town meeting vote, but I would love to create on my land a suitable turnaround for trucks and whatever apparatus needs to turn around, and just call that
And the person,
it's done, and this is just a driveway.
and you're,
Because it would only be 2 lots back there, so.
Who owns that first section of that? Doug still?
Me.
But you own that, okay, and then you own that, so you own that, so you own the whole point.
I own,
Yeah, we
I own
it.
the shore.
That's right, so you're,
Shore, and then there's a couple houses on the right. But that 49-2 goes, there's like 2 little islands out there, and then there's that little cove, and it goes on the shore.
yeah. Have you talked to a lawyer, like, I mean?
No. Not yet.
Because it's pretty confusing. Go ahead through your 5 criteria and.
So, number 1, the variance would not be in contrary to public interest because the issue was created when the town voted Article 19 with little definition as to what was the road being adopted. The right-of-way in this location has already been moved but not shown on a map at the town. 2, the spirit of the ordinance is observed. We are asking for relief from something shown on paper. 3, substantial justice is done. I would like to move forward with the project while the legal process that will take some time is working through the system. All of the affected parties and abutters are in agreement with that process to keep moving forward. The values of the surrounding properties are not diminished. My property is at the end, and I'm seeking to build a addition on it. I don't see any way that a property value could be diminished by anybody around there in that regard. 5, as mentioned previously, this is an issue created by the warrant article vote and is only one seen on paper. The actual traveled way there is not the old Cahill Lane anymore, and I've moved it further away from the lake, further away from my house, further away from my addition. And again, there's only the one house at the end, which was Doug Lieb's. My dad purchased it from Doug in April. I do have a letter from my dad supporting it. I don't know if you want to see that or not.
can I just ask you, can I ask a question, Terry? Are you the sole owner?
Yes,
Okay.
my wife might be on the deed. I don't know. Are you on the deed?
Oh, she's here.
Yeah, that's my wife.
Okay, good. As if there's more than one person, they should also sign all these documents. But we've been without a person to process, so.
I think it's just me.
Question.
Yes.
Go right ahead.
Are there any, it's difficult for me to understand exactly how this is working out, but are there any, other than your father's property, are there any other further properties down the road?
No, I can actually show you a better map.
And if somebody else buys your father's property, are they gonna be coming in with some kind of a request for a variance also because of where the new road is located?
I believe if my father has plans to do something to that property, that's gonna be a whole nother kettle of worms, because now we've got, a town road with 50-foot setbacks that we don't know where it ends, because it literally just goes right to his house. So, and there's on the survey that was done when the subdivision was approved, there's a little squiggle on the survey that says, town maintains road up to here, according to owner. And that's it. So there's no, it just shows the setbacks, and the town road just kind of ends. So when you talk about 50-foot setback off of the end of that road, I don't know what it is.
Okay.
But I can show you that map that shows up.
Any idea when the new Cahill Lane would be recorded?
So
When the time comes, there may be an answer to that, okay?
I don't know. The process I was told was I could either hold everything and wait and hope that this town meeting vote goes through and we can make the end of Cahill Lane not a town road anymore, the part that I own and that my dad owns. But I didn't want to wait until March, and then what if it doesn't happen? So I kind of wanted to proceed with the stuff, hopefully before the ground freezes, and get something done this spring, you know, while lumber costs are super sky high.
Yeah,
Actually,
It's
they're
a
going
great
down
time.
now.
That's what I've heard.
Only costs your left arm instead of both.
Could we, while you're searching for paperwork here from
Yes.
Dale on this, are you here to speak to this case as well, or just hanging out?
This is the case I'm here to speak to.
Okay. Could you
Okay,
come
we'll
on
come
up?
right up. Are you here to speak on this too, John?
Nope.
Oh, you're just, okay. I saw you with your arm up for a minute.
It's understood, that's fine.
You were just stretching.
So,
It just wasn't public
I understand, no, I got it.
comment time, I apologize. Okay.
This is a better map, actually. Show you. This is the shoreline permit when I moved the road. So here's the lake out here. Here's the existing, the old Cahill Lane. This is the part that I'm supposed to reclaim with vegetation. Here's the new one, and here's my existing house. And then this is the only other house at the end up here. My property is right about here. This is a vacant lot that I own, and this is my dad's property. So the road goes like this, and now I've changed it to go like this, but it ends up here at this house. You can kind of see it on this one a little better.
Yeah.
See how the road,
Probably to
this
the
is what I mean by where's the road end.
And it probably ends at the property line.
Okay.
That would be my,
Well, yeah, but it
my
doesn't,
assumption. I mean,
I mean, that thing was so poorly written. I mean, that, the driveway that goes to your house could be part of Cahill Road. I mean, you know.
well, that's private land.
But that thing was just, you
So
know,
this is the
out there, so.
shoreline permit. It's a better map of exactly where the new road is. So here's the old Cahill Lane that winds around
Right here.
right past my house.
Yeah,
And then here's the new one. So you can see this is
Yeah.
significantly further away from the lake and my house. And this is the area marked to be reclaimed with vegetation.
yeah, okay.
And this one's your dad's?
Yes. So that's an empty lot
Yep.
that
It's
I own.
Want to see that? Did you see this?
I did.
your Pirate Islands.
Can you show
Yeah,
us?
supposedly.
Did you want to see this? Paul?
Yeah, thank you, Terry.
It's only an island, well, the lake's up high though. And you can walk to it over there.
Okay,
Dale Sylvia, building inspector again, for the record. As I said in the previous case, it's not our role to be in support or against anybody. We're just here to enforce the rules. And that's really kind of important. We don't have an opinion. It's extremely tough not having an opinion on this case. And the reason why is, as you all know, a petition warrant article was passed last year, this year, and the way it was written and what was presented by the people, I don't think they understood the repercussions of what they were voting on. It's immaterial, they voted on it, it passed, this is now, in essence, the law, and this is what we have to enforce. So I'm the one that denied Mr. Bergeron, and as I'm doing it, everything that I'm denying, I don't believe in and I was against. But that is what the law is and that's what the rules are. I don't believe that that was the spirit or the intent of our ordinance. That's not what this was about. Unfortunately, and Terry, as you just said, I believe there's gonna be a lot more to come. I believe we're gonna be having this conversation many times over the years coming up. What happened from that is basically they've adopted all the rules that came with it. Now, in this particular case, and ironically, and I compare it to that 28-3 moment, everything went against them that possibly could. And it was not by any wrongdoing on their part, but just every step of the way and everything that we thought maybe we found a way out of this was not there. It just worked against them on every aspect. I believe that they did act in good faith, and the main reason I'm coming here tonight is just so The zoning board understands that the town doesn't really dispute any of the things that they said to make sure that they understood how this went down. So when they changed the road from the old Cahill to the new Cahill, that was totally fine. The town didn't care, it was no big deal, it was private property. We just, you do what you want on your property. The problem is like he said, it wasn't recorded. That didn't matter anyways, because nobody in there, wildest dreams would imagine that somebody would come and change this to a town road. Because one of the things that we haven't even considered with all this, which is a much bigger issue than here tonight, is when you adopt a town road, it has to come up like when a developer comes in, you have to bring the road up to standards, and even then we wait a year or two to make sure. None of that happened. So we have all of these roads that, as he said, on his father's property, we don't even know where it ends. There's so many problems with this that are gonna come in the future, and if there was ever, one of the 5 criteria is the hardship, if there was ever a hardship, this is the case. Everything that could possibly go against them has. So the old road, we looked at it, I've walked it, it's still physically there, but it's not the intended to be a road anymore. They have a new road, which is approximately 40 feet or so, 30, 40 feet, whatever, over. That's the new road. The old road, by law, we gotta go by what's on paper, what was recorded. So the old road is what the town adopted. And that is right in the middle of, or right adjacent to where they wanna put their addition. I have no choice but to deny it.
And when you say recorded, is that tax map recorded?
No,
Yes.
And that's the only record?
That's
Registry.
the only record that exists of it.
Understood.
So that's what's there, and that's all we have to go on.
So-
Now, we've sort of, I don't want to really say a plan, but we've had some discussions with Mr. Bergeron about possible solutions, how to get out of this, and this was to answer your question that you were asking earlier, when would this be recorded? There's a bunch of different ways that we could do this right now. The problem is they want to build an addition, and they have the right, they don't want to wait years for this. So they are electing to apply for a variance tonight and try to deal with the road situation in the future. What that would be is, I believe they're gonna come back and ask for that portion to be discontinued, which can only be done by the people. The town can't do it, the selectmen, the people have to do it. So that has to go through the whole legal process, then we have to discontinue that and give it back to them. And at that point, one of the things to avoid this in the future, because it's not just this case, it's all the cases that are coming, we want to set precedents, it'll have to be recorded, and that would be done at that time, to answer your question. So if we do change this road, that would be probably one of the conditions that we would put on it to make sure to avoid this problem. One of the things that, and it doesn't really pay any difference in your vote tonight, but I would caution you to, several times I've heard ask who owns the adjacent properties. It doesn't matter that his father owns the property, or even one of the abutters is himself. It doesn't matter. We don't look at owners. We look at lots. They can sell it tomorrow.
What's on
So
record?
it doesn't make a difference who owns it and that they own all that land. That's the only, and it's not even a negative thing, but I'm just saying it's not a positive thing for them as
But the
far as,
reason-
it shouldn't be considered.
Right.
We don't care who owns it.
No, we're here.
But the reason I brought it up is he owned it all.
Yeah.
Now, and it became a town road. He could have said no then.
If he came to me in May instead of July, we wouldn't be here. There would have been no denials at all. This would have been straightforward. He's got the land, he's got the room, he has the lot size. As far as the waterfront, all of that is fine. It just wouldn't have been a problem. This is a 100 direct result of, was it Article 19, I believe it was? Article 19, this is one of the repercussions, and part of the reason I'm also here tonight is to let you know there's potential of seeing a lot more of these coming.
Now, question, it says simply less than 50 feet. How close is the old road, which is what we have to go by, to your dwelling unit that you want to add?
So,
In feet?
do you have this plan in
Yep.
front of you? So you can see the
Smaller version.
perfect rectangle there is my existing dwelling, which is currently 24, the closest part of my existing dwelling, as it stands right now, is 24 feet from the old Cahill Lane. I've got a plan here that shows off of the addition, 26 feet away, so 2 feet further, and 46 feet away to a back corner. But then the closest portion to the old Cahill Lane is my builder put in some steps to get up to the porch. We don't know how many steps we're gonna need, we don't know where the finished grade's gonna be, but he thought worst case scenario, we would be 20 feet. So right now, as it stands, I'm 24 feet from the edge of Cahill Lane. I'm asking for relief here in this area, which is 20 feet, 26 feet, and I don't know if you put it in your notes, but I've got one that's 46.
Here's my denial.
Right, but, I mean,
No,
Yeah. We usually do.
no, we did not have, I don't,
no.
no.
All I have is his application.
We almost always get your
And a
denials,
letter
but
from Chris.
it's just not here this time.
But I mean, the other problem is, I mean, if this was, originally this was all one piece. Then Doug divided it up into 3 lots, and then you, I mean, now you're, if you were a non-conforming lot,
That's what I was just gonna
you'd be
ask.
20 feet. But you're not a non-conforming lot because it was a subdivision.
So I actually, because my lot's bigger and I have more room, I'm subject to the
This
Right.
lot has
Setbacks.
20
stricter.
No, but that's what I'm saying, but even the two, right. But before, at one time, I mean, it was all one piece. It
Yeah.
was just like a lot.
And the, to speak to that, the conforming lot that I wasn't around or during the time where it was subdivided and how he made this all a conforming lot, but the 200 feet of frontage is a very bizarre radius, cut of my lot. So the lot line there is fairly bizarre if you look at the, tax maps. But in order to satisfy the 200 feet of frontage, it is a pretty bizarre lot line.
Right.
Even though it's not a public road.
No.
So, can I just ask another question about your right-of-way and the new one? Did you, who did you get the original right-of-way from? It must be in your deed.
It is.
And then who granted that? Would you need that person to re-grant the new right-of-way, or who would grant it to you, or did you not draw up any legal paperwork? Because you can sell something in New Hampshire and not record it, and it's perfectly legal, as long as the person that sold it to you doesn't sell it twice, and the second person recorded ahead of you. Isn't that right, Romeo? You don't need to record things by law.
If
If you want to protect your property title, yeah, a deed. But a right-of-way is by deed, generally.
Right.
Right, but then you don't have any, you don't have
It's
anything to
not a
stand
right-of-way in
on.
this case, though, because it's on his property now. So it was initially, the road was going as a right-of-way to the property beyond. He's not asking for a right-of-way because he
I'm
just moved
granting
it
an
on his
easement.
property.
So he
He's
did-
granting it to somebody else
So
to get through.
in the spring, he's going to just cut it off, or try to.
But there's a new one, the new Cahill.
Cut
which
off the
is-
old part,
Yes,
up to the new.
right.
The old part
And that
is-
was part of the
Extinguish
denial
it.
because there was a right-of-way that we wanted to make sure that the house beyond, even though it's his father, this is what we were looking at, had access. They do have access, but it's not recorded. And that will happen in '22 when they come forward, you know, with everything. And if they don't, then the old road is going to be the road until he solves that, and we're not gonna let him move over to the new road. Because he was looking, like he said, is to reclaim that, which, one of the things, it's not just a question of him, we're saying you can't do that now, because that is the road. You
Right.
can't plant grass on our road.
So
So there is no right of way though, per se for him, it's for the next lot over.
If we grant the variance, it's gonna be off the old road.
Yes, sir.
And
Right.
by rights, because we grant the variance, he's gonna have to use the old road. Unless he reverts it back to a private road and then he can move it over, right? Is that the way
Well,
it's
not
gonna go?
necessarily,
So
because
if we grant the variance,
if you grant the variance,
he's not gonna have to do anything.
right, he doesn't have to use the road. The other road is still his property, and he can still drive on the other road if he wants. All we're saying is the old road is the town road, that's town property. You can't change it, you can't plant grass, that is the town road. He doesn't have to use it, he can still use the new road, which is just on his property, and he's got a right to drive wherever he wants on his property.
But you're saying if he had recorded the new road,
If you
the
recorded
new road would be
road-
part of the article.
Yes, the new road would have, if it had moved over,
But-
that's what the town would have, adopted in Article 19. But because it wasn't, we legally adopted this other portion.
I'd ask
And that's
a
where
lawyer
it gets
about it.
so messy. But the right-of-way, there really isn't a right-of-way for him. He's granting a right-of-way to the lot beyond him.
Well, there's something in the deed, I mean,
Yeah, so
this-
the,
your father bought that, I mean, there was a.
lot 49-2 owns the majority of Cahill Lane. And in the deed, lot 49-2 grants an easement to all the other residents of Cahill Lane to access on and off Cahill Lane. Lot 49-2 grants an easement to my house on 49-1 to access, and lot 49-2 and lot 49-1 grant an easement to lot 49.
So you would be the grantor again this time?
I would be giving an easement.
And I don't believe it actually changes, correct me if I'm wrong, you know better, but the point of entry, like he moved the road on his lot, but I don't believe it's actually a separate,
no.
it still connects right back to where the
Yes.
point of entry on the other lot was. So it doesn't change anything for the person beyond him. He just moved it on his property. So it doesn't
Well,
really
he
affect
moved
even
it,
the right of way
but
for the
he-
next lot over.
But he didn't move it on, I mean, he owned both lots, but he moved it on the first lot, which he's not on, he's on the second lot, and he's looking for a variance. So he moved it on the first lot.
Right, for the
Right.
point of the variance, it has been moved. For
Right.
the right-of-way portion, though, what I'm saying is, it was basically like this,
Right,
and what
he didn't
he's
move
done
it.
is he came around, but it still connects to the
Right,
same
he's still
point.
on his land when he finally connected up, so, but he cut it off his land back further, so that, it's confusing.
And even having said that, though, if we were to look at it, and if he were to come to us if it had nothing to do with Article 19, he was still actually making it more conforming, not less conforming, because he's getting farther away from the water. So it wouldn't have been an issue for us anyways, if he wanted to move this road over. Let's say it wasn't private property, or there was some reason we had to, because we had no jurisdiction over it, but if we did, he was making it more conforming, not less conforming.
The whole issue before us, though, is not the change in the road, it's the fact that the road that is on
Right.
record is what we have to go by.
Right.
So my question is, you're gonna be within 20 feet of this road, of this class 5 road with your...
20, my existing house, sorry to interrupt you, I
The
didn't mean to
addition,
interrupt you.
the
Yeah.
addition, the part that you're gonna be building is gonna be within 20 feet of the class 5 road.
Part of it,
Correct, but we have to, that's what we're here for, is for that,
the steps.
And
it's part of the structure.
Yes, it is. I'm not disagreeing.
Okay,
And if we grant it, then does it force that old road to stay the old road?
No.
Well,
In
according
any
to
way,
Dale, no.
you know?
well,
does
the
that-
other part I'm concerned about is
I'll answer that in a second.
legally, should we be doing anything with a road that doesn't even exist?
Okay, so what we have in front of us tonight, if I may, let's just forget about the new road.
Yeah, well,
The
that's
new
what I'm trying
road
to
doesn't
do.
even exist as far as
We're
legal.
concerned.
Doesn't
Correct.
exist. What you're asking for tonight is the old road, or the existing road, is a legal town road now. And he wants to build a addition within, what he's asking a variance for is, he's gonna be 20 feet where 50 is required. Now, keep in mind, his house itself is within that 50 feet too, but when it was built,
Was a
excuse
private
me, when it
road.
was built, it wasn't a problem because that wasn't a town road. So all we're asking for, or not we, all he is asking for is a variance to build, he doesn't meet his front setbacks. That
Variance
is
to
it.
the setback.
Correct.
As far as whether he builds this or not, whether he gets a variance or not, whether he does an addition or not, that doesn't affect whether that old road exists and will exist until he comes to the town and gets the people, and even if he comes to the town and the people say no, then he still can't get rid of that road. What you do tonight has no effect at all on whether that road is a legal road or not. That is the town road
Right.
until the people say it's not.
So, but if that's a town road, anybody has a right to drive over it.
Yes. Right now, somebody.
Right now, you can just drive right over it.
Yes.
So,
That's
I
one of
mean, he
the,
has the other road, but you still have the right to drive over it.
that's one of the repercussions of
And
this
that's
vote.
one of the
that
repercussions.
We're gonna have, neighbor against neighbor or whatever, but anybody can go down his road and drive within 20 feet of his house right now.
Right.
That is my question about the 26 feet, because or 20 feet, whatever it ends up being, is it's going to be like,
So the addition itself, it runs parallel. He is not coming closer than his existing house. He's running
Okay.
parallel with,
I've got it.
Bigger one though?
I did. Yeah, in the map, doesn't really matter,
picture his house is here right now, the road is here. He's putting the addition here. So it's not like he's coming, the house is here and he's coming that much closer to the road. He's just running parallel with the road, but that is within our setbacks now.
okay. John, you've been wanting to say something, I think you're gonna climb out of your skin if you don't get it off your chest.
He's looking for, and again, I'm speaking for, but he's looking for a 20-foot setback on a road that's no longer gonna be in use, no matter if it is a town road or not a town road. I live at 23 Cove Road. My house only stands, of course, built in 1967, only stands about 24 feet back from where the road, Cove Road now exists. My neighbor's the same thing. They meant it's only 25 feet. The neighbor down the street wants this. What he's asking for tonight, in the 20-foot setback, is nothing that this board should have a problem not approving for him, because he's just looking for a variance we can build.
I get
So
it.
he's really just looking for a simple
Cut it out.
variance.
I get it. Thank you.
So that's, again, there's tons of houses out there that are closer to a town on these roads than what he's even asking for. So I just think it's a simple approval. I don't see what the question about where the road is or what the road has anything to do with it. He's just looking for a 20-foot setback, which should be something that's easily approved.
Mr. Chairman, I'd like to make a motion.
I was saying the other road doesn't matter, it's this road, and that's what, wanted to know what the setback was, because it only says less than 50, it didn't specify an amount, and I just wanted to know what it was.
Absolutely.
Do you, for the sake of formality, I did do a denial on this. I can submit that with it. I'm not sure why you don't have it. I believe I did give one to you too. I don't know, but.
I don't know if my phone took
But
that.
20 feet would be the maximum that we would be approving encroachment on.
All right, I just wanted to know what that was, that's.
Yeah.
Mr.
Well, that's a
Chairman?
very good point, because it's an exact number that we're asking, that we have to approve. or
Can I
not.
just say that all this other stuff created weeds that we really didn't need?
I think this is just the beginning.
Right.
No, I'm,
Get used to it.
I think it created weeds
if there,
and a rabbit hole.
here's another example which is gonna be far worse than this one. Let's say you have a house here.
That's not.
Yeah.
Let's.
Mr. Chairman, I'd like to make a motion.
But the problem is.
It's okay, let it come when it comes, but let's.
Close
deal
the
with
hearing.
this tonight.
Yeah, well, I just wanted to say one thing. The problem here is you want the best of both worlds. You want the town to maintain the road, but, it's, there's no guarantee. We do this, there's no guarantee you're gonna have it returned next year, right?
Have it what?
Have it, if we give you the variance now, there's no saying, you have to go to the town and withdraw that road, right? And make it a private road.
I would love to be
Obviously,
able to do that right now. I've been begging to do.
Yeah, I know, but but once we grant the variance, there's no need for you to do it. Other than the road would exist there somewhat.
And it'll be
If I wanna
plowed.
build something else in the future, I'm gonna need a variance because everything on my land is within 50 foot of the road. So it's in my best interest to make that not a town road.
That's down the road.
No matter
We could,
no matter what I do on my property, it's all within.
we could put that as a stipulation, but I don't think it's gonna be binding.
That would help my case to make it a.
The difference though with what you're saying is it's not like something he's promising to do. The road already exists.
Right.
The new road is already there and they're already using that. So
Right.
it's not a question that he's not gonna come back.
But the problem is that road is there, and according to law, anybody can drive down that road, the road that's closest to his house. Yeah.
Mr.
So
Chairman,
that's where the problem was.
I'm requesting that we close the hearing and move to vote.
Yeah.
I'm ready to make a motion.
Yep, I'll close the case and open it up for a motion.
Okay. I'd like to move that we accept the application from Matt Bergeron case number 21010-VA, for a variance from Article 2, Section C3A, construction with less than 50-foot setback. The property is located at 8 Cahill Lane and is known as Tax Map 68, Lot 49-1.
Second.
We should amend that to a 20-foot.
It's.
Less
the-
than 50.
The application was for is less than 50, and it doesn't matter, it's less than 50.
Okay.
I would like to make a stipulation that he has to remove it, that it has to go back to a private road, but.
He can't do that because it requires a town vote.
People have to vote on that, you
Right.
can't,
You
you can't make
can't, you
this.
can't hold him to that.
Right. Okay, well.
We know he wants
go with the
to.
vote. Okay, we have a motion and a second to grant the variance on this case down to 20 feet. So all those in favor, raise your hand.
Aye.
Okay, all those opposed? So it's 4-1.
Who objected?
Here we go.
You objected?
Yeah.
Oh, okay.
Only because I think, you kind of got to live with what you did. I mean, he had an option, he could have gone to them and said, I don't want to be on there, so, but he wanted the best of both worlds, so unfortunately.
Unintended consequences.
Reminder that you have, is it 45 days?
30.
Yeah, you have-
30 days for
30,
anyone to
40.
appeal.
Is it 30 or 45? Because I know it was.
I know,
It was going to change, but I'm not sure it got.
It didn't.
It didn't get
Joanna
changed.
corrected me, in fact, so
I
it's
think the
30.
30 is correct.
Yeah.
For
That's what
anybody
we've
to
been
object.
saying.
Not that they will, but you do.
Thank you.
We have to warn you.
Good
All right.
luck to you.
Take care.
He has a permit to put in the new road, and it says reclaim the old road.
He doesn't have a permit to put in a new road, he didn't need one.
Well, he had a shoreline.
Shoreline.
He had to get a shoreline.
So he is not compliant to the shoreline yet.
Yeah, we went through all of that.
And then, would he ever be if
He's
if
gotta-
nothing changes?
He is in compliance with shoreline. What we're referring to there is if the new road gets adopted, the old road disappears, and that would be the shoreline that would get reclaimed.
But
But he can't do that right now because it's our
But he
property.
had to get the shoreline in order to put the new road in.
No, he didn't,
Oh, he did not?
because
Okay.
that was private property and it was farther away. That wasn't within,
The town.
I don't believe he had to get a shoreline permit for that.
Oh, okay.
He didn't have to because that was
Okay.
outside of the we didn't have any jurisdiction, the town didn't. But, I believe it was outside of the distance from the shoreline permit, so he didn't even need to do that.
I see.
But he did go for it, and it got approved, right?
But someone's telling him he has to reclaim the old road.
And it got approved by reclaiming
That
the
is
old
something
road.
that I believe, and don't quote me on this one, I believe that to get the addition to the house, he has to have a shoreline permit for, and part of that deal he worked out with them is that whole road is gonna be reclaimed to get the non-pervious space.
Sure.
So, but that's not something that, it's not part of it, like, I see what
Yeah.
you're saying, is why would we give them a permit if they don't do that?
Right.
Yeah.
So, you want him to be compliant, and somehow
Yeah.
he has to reclaim the road per that
I don't know if
agreement.
that's a requirement.
Okay.
Which we can look at, that's a good point. I don't know if that's a requirement, or if that is just, something that he wants to do because he wants grass in his front yard.
I think he said it was a requirement.
Sure.
I think that one of the bigger issues
Because
is
unless it gets
that,
taken back, I mean, they could drive right through it. So-
But they can right now too.
No, but I'm saying that.
Well, he
that
said it's
really
blocked
can't-
off.
He can't really fill it in, he can't do anything.
That's
to it
right.
Until he gets it withdrawn.
He doesn't own it right now.
Right.
You own it.
Right.
We own it,
So
not
that's
we,
why-
you, the people.
The town.
and I think this
No.
is one of the things that we're
He
saying.
still owns the land the road is on.
Right.
He owns the
Yeah,
land.
but we own the
You
road.
own the road that's
You own
on
the
the
road,
land.
Yes.
Right,
Yeah, on the
exactly.
right of
Town's
way.
property.
But he can't plant grass on your road.
I
Can't
understood.
obstruct the
Okay.
right of way.
You're right, he does own the land.
Because I hope I'm in the same boat.
Well,
I
you
think
might
the
be.
bigger
Did
issue,
were you on Article 19?
Well,
He lives on
He's
the,
on
Lamprey.
the- he's on-
Lamprey. So, yeah.
I think people did not realize the implications of pushing this through.
Oh, yeah,
And I
for
think it
sure.
was pushed through without
We still
real
own it?
serious thought.
Right. They wanted the best of both worlds. That's,
Yeah.
Are you guys doing a public meeting?
Yes.
Or are you closed your meeting?
We have
No,
not, we
haven't
have
closed
not
the meeting.
adjourned.
Nope, we're still talking.
What do we do with this?
You leave it there.
They give it-
For us,
Mr. Chairman.
Yes, because you loaded
I
up
don't
with
care
green.
either way,
that's
like, whatever happens, we're just gonna, like I said, we're gonna enforce the rules.
You have no choice. There's nobody here for public comment, but we do have
Minutes.
minutes.
Yep.
And I believe it is from our.
Are you all set with me?
Yes,
Yep,
thank
we're
you so
good.
much.
Thank you.
Thank the board for letting me talk tonight.
You'll be here a lot more, I'm sure.
You have the list of minutes, I remember.
The minutes were from the last, our last
From
meeting.
August.
Yeah, you weren't here.
I was not here in August.
It was a quick meeting.
It was a quick,
I was getting my knee,
We were here for the,
yeah, you
we
were gone. It was a very quick meeting. All we did was,
were here for the rehearing, and there wasn't a full board.
there was no rehearing, there was no 4 people, there was only 4 people. They chose to go to,
But have those minutes been distributed?
Yes,
I don't think I've
minutes
seen
have been, yeah, they went out. I actually read them. Yes. It wasn't open and closed. Lorraine sent them out the very next
If I
day.
was here, I didn't see it.
no, you weren't, well,
He was.
yeah, you were,
It was me,
So I-
you were
you,
here because we had
That's what
4.
I said.
Romeo was out, Teresa was out.
You-
So that would've left 3. You had to be here, yeah.
Along with Raylene, but Lorraine sent them out the very next day.
Yeah, she was quick.
Hard copy?
Practically sent them out that night.
No, we get them all through the email,
Yeah,
I got 0.
okay?
you must have got
So I
this.
have to.
Lorraine needs,
I have to sustain because I haven't read them.
Well, we can approve the minutes. Let's wait on the minutes and we'll,
and I wasn't there,
Right, so
so.
then we can adjourn.
what's that?
I said, now we can
Yep, okay.
adjourn.
Do we have a motion to adjourn and
Move
we
to
have a
adjourn.
second?
second.
Wow, there's a lot of people. 3 seconds. Okay, we have a motion and a second to adjourn. All in favor? Aye, aye, aye.